Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. Not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning. I don't have much of a voice today. I can see that StreamYard is already having issues. So if I am glitchy, let me know. I'm on Ethernet. Shouldn't be a problem, but it looks like StreamYard is having a problem. So last night was amazing. Here's what I did last night. And for those of you who do love Dave Matthews, here's the set list because, got the set list. Your girl gets the set list. She's always up in the front. And here it is. Remember you said, somebody said, how many of you are Dave Matthews fans in the chat? Oh, it's going to be a long morning. I have no voice. Any Dave Matthews fans in the house? We have a Dave Matthews emoji wildflower. Yep, we do. We have a dancing, a fire dancer emoji for my love of Dave Matthews. And there's the set list for you if you're the court the fan is on. We got a couple of minutes to chit chat, so don't worry, we're not going to miss anything. It's the charging conference today. They're going to talk about jury instructions. I also anticipate that they are going to talk about the curative instruction with regard to the canine DNA because Hank Brennan is waving, maybe he's waving the white flag. He's jumped off the ship and he's like, I'm not even going to put on a rebuttal case. And we'll talk about that in a couple of minutes anyway. But here we go. So I got my Gray Street. I got my Stone, which I also love. And I think I said Crash yesterday. I wanted to hear and Every Day. So I got all of those songs there. Set list was Drunken Soldier, Gray Street, Stone, Only Thing, Big Eyed Fish, Bartender, Stay or Leave, So Right, Crash, Jimmy Thing, Every Day, Do You Remember? Rhyme Spoon, What You Are, Trippin' Billies. And he played Thank You for Sly Stone, which was so amazing. I want to thank you for letting me be myself again. And then two-step encore. And a song that I had never heard before, a nice ballad at the end. He did talk a lot about, at the end, being kind to each other and, got into politics a little bit and, about how we got to be kind to each other and stop all the fighting and the nonsense. And it was awesome. And I can't play the video clips for you. I guess I'm going to put them up on my Instagram later. So if you don't follow me on Instagram, you might want to if you're interested in this kind of thing. But this is how close I was to Dave the entire night. This was my view of the night. And I was that close. I was probably 2-3 people off the rail. And there was a kid in front of me, so that was good because he was short. Usually I find myself behind the tallest men in the world. Not many exist, but every 6'4" man is usually standing right in front of me. And what a night. My heart is full. And so many songs. I mean, I love music. Music is my life. It really is. When I used to follow the Grateful Dead around from the time I was in junior high through high school, college, for my entire life, the one thing that you could always count on with the Grateful Dead was a spring tour and fall tour. And it was kind of, for me and my friends, it was like setting the reset button of life. You know, if we can just make it to the next tour and the next shows, it has the way of just resetting your life button and sort of helping you get through whatever stage of life you're in, you know, whether it's adolescence, being a teenager, breakups, college, marriage, divorce, children. The Grateful Dead were always there. It was the one constant in my life. And there's nothing like, you know, being in a place where tens of thousands of people are smiling for hours. And one of the great things about Dave Matthews that reminds me a lot of my time with the Grateful Dead. I used to say the Grateful Dead are following me around. They're in court today. The fan's up. Don't worry, we're here for it. I digress occasionally. Is that Dave Matthews also plays a different show every night. So if you go 3 nights in a row, you're not going to hear the same show, which is unlike a lot of new artists. And the Grateful Dead were the same way. You could go to 10 shows in a row. You would never see the same Grateful Dead show twice anyway, because it was always different. They certainly didn't play things the way they were on the album, and they didn't make their money from album sales. They made them from touring. They made the money from touring. And they were one of the very few bands that allowed people to tape their concerts and trade cassette tapes. And Dave is the same way. You'll never see the same set list twice. Okay, they just went into court. I've got the fan up. You're not going to miss anything, okay? It's here. It's up. I'm on it. I've been doing this for a little while, you guys. You may be new to me, but I've been doing this for a while. You're not going to miss anything, I promise you. Oh, thank you. No, I did not. John Stamos gave Free Karen Reed a shout out. That's crazy. Where did that happen? Anyone seen Bev's Grave Concern? I didn't. I haven't seen Bev's Grave Concern in quite some time. I did not see that, but I would love to see that because I love John Stamos. Let's just say, who doesn't love John Stamos? Oh, good morning, Big Hoss. Good morning. Thank you for your super chat so early. Welcha, Melanie and her awesome group of moderators are awesome, and I thank you all. Thank you. Thank you, Welcha. Patio says, I have a bottle of NA Rosé ready to pop when we hear the not guilty verdict. Free Karen Reed on Friday the 13th. Cheers to all you good people. It might happen. It might happen. And remember yesterday when we hung around after the jury was dismissed and we waited, and every single mainstream media outlet was reporting that the defense had rested, including Ted Daniel. What did they do? Did they just like run out of the courtroom the second that the jury was dismissed and just start tweeting that the defense had rested? The defense has not rested. And the chat was going crazy talking about that. Everyone has said and telling me I was wrong. I'm wrong. The defense rested. The defense has not rested. It is done in front of the jury in open court. The jury had already been dismissed. Alan Jackson said he was waiting for a PowerPoint. They're talking about a PowerPoint presentation that they want to get into evidence. It had only been marked as an exhibit. She didn't make a ruling on it yet. Kim Jong Canone, Lady Macbeth, Aunt Lydia. I'm sorry, what's her name again? I forget her name. The judge that is presiding over this Shonda of a prosecution. John Stamos was on stage and gave Karen a shout out. Is it on you? Is there a clip of it on YouTube? On stage for what? Does he sing? Does he have a band too? If anybody wants to email it to me, my email's in the show notes. Okay. John Stamos and Emily D. Baker's super chat last week, sending a super chat. Melanie, your name is Melanie, so I know that you're like not gullible, but do you know how many people change their usernames to other people's usernames? I don't believe that was actually the real John Stamos and Emily Baker's chat. Highly doubt it. You could change your username right now to anything. You can be anybody. But if somebody says that there is like a clip of John Stamos on stage saying that, I would love to see it. Again, saying that John Stamos is in Emily Baker's chat, I don't know. He messaged her privately. Okay, did he get on video and give her a video chat? Do you guys know how many trolling? John Mayer John Mayer actually, emails me all the time, but it's not John Mayer. I don't know. All right. Well, if she confirmed it, then maybe she video chatted with him. I don't know, but that's pretty cool if it's true. Friday the 13th would be a great day. Before Father's Day would be great. We're going to do the charge conference today. They're going to talk about jury instructions. They're going to talk about the curative instruction about the dog DNA. I'm sure perhaps Alan Jackson is going to, I don't know if they can make their motion for a directed verdict until after they rest. So I don't know if that's going to happen today. That motion is always made. They made it after the close of the Commonwealth's case, and now they're going to make it again after the close of the defense's case. And so that is basically, Judge, you have to direct a verdict in favor of my client and acquit her of all the charges, because there's no way on God's green earth that any jury could ever find her guilty based on the lack of evidence that the Commonwealth has presented to the jury. In fact, there's no way that they've even proved a car accident. And so you must acquit her. The judge will inevitably deny it because most judges want the case to go to the jury. It is rarely granted. Do not be upset when it happens that it is denied. And so there is that. But yes, so then tomorrow it is anticipated that defense will rest. I don't know if they will. We'll see what happens with the motion for a directed verdict. And then we will hear closings. And Alan Jackson asked yesterday for more than an hour for closings, because remember, during season 1, they were only allotted an hour for closings. I've been screaming since then that I didn't think it was enough time. Adam Lally got cut off during his closing, and he was allowed one more sentence to finish his quote. I think it was a John Adams quote, right? Because everybody's always quoting John Adams in this trial. It seems that the judge loves to quote John Adams, and she'll probably quote him in her jury instructions too. So it's anticipated tomorrow we will hear closings from both sides, because Brennan has dropped his rebuttal case, either out of fear that Welcher is going to kill him because he wasn't provided with the x-rays. And I guess he's abandoning the lack of dog DNA. So they're going to have to cure that somehow, because that was one of the grounds for the mistrial that was argued. One of the mistrial arguments that were made here. They moved for a mistrial with prejudice twice, the defense did. And one time it was because of the dog DNA, right? Because, the playlist is in the show notes below. It's on Spotify. It's a Spotify playlist. Thank you for asking. And so there needs to be an instruction on that. Hank Brennan started questioning. I'm conflating now. I think it was Dr. Russell. Are you aware that there was no dog DNA found on the sweatshirt? I'm like, whoa, take a step back. And then Alessi moved for a mistrial based on that, right? Because it was intentional and he's putting evidence out there. Okay, the judge is taking the bench. Thanks, Cusco.
You are unmuted.
Got it. Friday the 13th would be good.
Was now open, you may be seated.
Good morning, Your Honor. May I call the case?
Please.
For the record before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present. The matter is on for trial. If the parties could please identify themselves for the record.
Good morning, Your Honor. Laura McLaughlin for Commonwealth.
Good morning, Ms. McLaughlin.
Adam Malik for Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Morning, Mr. Brennan.
Morning, Your Honor. Robert Alessi from Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti, and good morning, Ms. Reed. All right, so Mr. Yannetti and Mr. Alessi, you're standing in also for Mr. Jackson and Ms. Little?
We are.
Okay. All right, so first thing we left off yesterday was whether KKKK for identification, the PowerPoint of Dr. Rentschler would be entered into evidence. It will not be based on the objection, so it is excluded from evidence.
Ridiculous.
So it's marked still for identification, and your rights are saved on that. So we ready to go forward with the charge conference?
Yes, Your Honor. I guess I have a question first as to whether the court would like to entertain the argument on the motion for the required finding not guilty of close all the evidence. and go to the-
So, no, we can do that now. So now that my ruling is on this, evidence is closed as it was yesterday. So go ahead on your required finding argument. Sure.
David, please find a mic. Thank you. Alan Jackson is not present because he's preparing his closing. And so I'm sure they all spoke about what they want to say today. And the PowerPoint of Andrew Rentschler, those names are too similar. The PowerPoint by Andrew Rentschler will not be admitted into evidence. That means the jury can't have it to deliberate with, but no surprise there. David Yannetti will now get up and make his argument for a required finding of not guilty. That's the motion we just spoke about. I called it a motion for a directed verdict. They call it different things in different states. And so let us hear his argument. King David is here. The jury is not and will not be today. Okay? Ready? If you're ever confused about what's happening, I have things scrolling at the bottom of the screen to let you know what is happening. Okay? All right. Here we go. All hail King David.
This is not lengthy, Judge, 5 or 10 minutes.
Take your time.
Thank you. We are renewing our motion for required finding of not guilty at the close of all the evidence, and in so doing, Your Honor, we're incorporating our oral argument in support of this motion that we made at the close of the Commonwealth case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with his having been hit by a motor vehicle, and if he was not hit by a motor vehicle, none of these 3 indictments may stand. The Commonwealth, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth's case has been further weakened, such that none of these charges can stand. Nearly every witness, Your Honor, we have called, we would submit, has destroyed the Commonwealth's theory of the case. Dr. Russell testified for the defense. She's a leading expert on dog bite wound pattern recognition in the country, and she testified about medical injury causation and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with dog-inflicted wounds, both bites and scratches. I would remind the court at this juncture that there was a dog at the very residence where John O'Keefe was found, a dog which was a longtime member of the family, which the family gave away after John O'Keefe's death. A dog which mysteriously was absent from the home at 6:30 in the morning on January 29th, when Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept. A dog which was absent from the home when the Canton police entered the home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Scorti-Bello, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. And again, if there's no collision, there's no case. Dr. Lopesada, one of the most experienced and accomplished forensic pathologists you could find anywhere, agreed with Dr. Russell that John O'Keefe's injuries were consistent with an animal attack. And she agreed with both Dr. Russell and the Commonwealth's expert, Dr. Scorti-Bello, that John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case where expert testimony on both sides is that the evidence is inconsistent completely with the Commonwealth's theory of the case, that's exactly what we have here. But it doesn't stop there. Both witnesses from ARCA drove a stake through the heart of the Commonwealth's case. Dr. Wolf concluded that the damage to Ms. Reed's Lexus was inconsistent with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, a meaningless experiment based on no scientific method, Dr. Welcher actually did the proper force analysis and concluded that Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case. Dr. Rentschler further cemented that there was no collision between the Lexus and John O'Keefe. It is simply not possible that this 6,000-pound SUV hit John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to his legs or lower body. The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over. But on top of all that scientific evidence, Your Honor, there were 3 additional fact witnesses who testified for the defense who corroborated that the Commonwealth's theory of the case is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. Reed's SUV that day, before it was towed to the Canton Police Sallyport, the taillight was merely cracked. When he was shown photos of what it looked like in the Sallyport after Michael Proctor had access to it, Sergeant Barros confirmed that it was absolutely different. Karina Kolakithis confirmed that there were no problems between Karen and John O'Keefe that night, even remarking on just how sweet he kissed her on the forehead shortly before they left the waterfall. But perhaps more importantly, that kiss happened right in front of Brian Higgins, the same Brian Higgins who had been flirting with Karen Reed that month, the same Brian Higgins whom Karen had ghosted for several days before January 28th, the same Brian Higgins who had texted Karen that very night, well, and received no response, the same Brian Higgins whom Karen had given her back to all night, the same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video, the same Brian Alberts who is on video, hot, angry.
Brian Higgins. You just said Albert. You mean Higgins, right?
I meant Higgins, yes. Yeah, the same Brian Higgins,
At
who is on video.
Look at her interrupting him to correct Brian Albert to Brian Higgins. Okay, she's helping the defense now. I almost fell off my chair just then.
Video, hot Chris Albert on video, the same Brian Alberts who is on video, hot, angry.
Brian Higgins. You just said Albert. You mean Higgins, right?
I meant Higgins, yes. Yeah, the same Brian Higgins.
She finally understands the case. Knock me over with a feather.
Who is on video, hot, angry, and gesturing to John O'Keefe to meet him outside shortly before they left the waterfall and shortly before John O'Keefe was killed. And finally, Brian Loughran, plowing Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, very familiar with the Alberts residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that night by choosing not to follow protocol and call the DPW or the police about the Ford Edge parked on the street outside their property during a snow emergency. Brian Loughran confirmed that John O'Keefe was not on the front lawn at the Albert residence at 2:45 a.m. That means that Karen did not hit him. There was no collision. All the experts agree on that, including the Commonwealth's expert, and the only eyewitness that morning confirms it. Taking the evidence in the light most favorable to the Commonwealth at this juncture, with their evidence weakened by an airtight defense to these charges, these indictments cannot stand, and we urge this court to enter required findings of not guilty on all 3 indictments.
All right. Thank you.
People are pointing out that she's protecting the Alberts, and that's why she had to correct him that it's not Brian Albert, it's Brian Higgins. Oh, Lally is here? Good morning, Lally.
Thank you, Your Honor. Commonwealth requests that the defendant's motion for required finding not guilty at this juncture, as it was at the close of the Commonwealth's case, be denied. The state of the evidence is not dramatically changed since the Commonwealth rested its case in chief. Counsel makes reference to dog or canine. I would remind the court that there is absolutely no evidence, none, not even a scintilla of evidence of a dog. There is no evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't see it in the morning, which does not equate to there being an absence of a dog there.
Okay. All right, Lally. Look, we know they've thrown you to the wolves again. Nobody saw a dog there. And you just called the dog it. Okay. We know she's been in the witness protection program for some time and her name has been changed to Cora, maybe if that's even her. But why did you abandon your entire rebuttal case with respect to dog DNA? You're going to lose that argument at least. But I don't think she's ever going to grant a required finding of not guilty. But it's nice. It's refreshing, isn't it, to hear from Lally again? Let's let him talk again some more.
The arguments from counsel of the Commonwealth would suggest grossly exaggerates the strength of the defense witnesses in their case. The bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine the Commonwealth's case in any way, shape, or form. A couple of specific examples when it came to Officer Barros. His testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave, he indicated the damage to the taillight was consistent with the damage that he observed in the driveway at the defendant's parents' home, which was then consistent from the video or the photographs within the Sally Port. It's also consistent with 5:07 a.m. at One Meadows Ave on the still frame shots from that Ring camera video. Essentially, the Commonwealth would submit that the defense witnesses all conflict with each other. You have a couple witnesses testifying about dog or animal bites. Then you have the ARCA witnesses testifying about superficial abrasions. You have Dr. LaPosada talking about the drop in body temperature, which conflicts with Mr. Loughran's testimony as far as his confusion, as far as the hours of when he sees or claims to have driven by there and not seen a body. This is the same witness who is, I would submit, very confused on times, and then also backed into a basketball hoop during the course of his plow duties on that particular early morning as well. And as the court could see from the cruiser camera video, drove by the scene countless times, essentially rubbernecking it as he's going past doing his duties. Your Honor, what the Commonwealth would submit is that his case was more than sufficiently strong at the close of the evidence in his case in chief. There has been nothing presented in the defendant's case to diminish, particularly to the standards in the light most favorable to the Commonwealth, and we request that the defendant's motion be denied.
Do you think that,
You know, I have to view this in the light most favorable to the Commonwealth.
I do, Your Honor.
And viewing it that way, the Commonwealth has met its burden, so the motion's denied.
Thank you, Your Honor.
Okay?
motion's denied?
All right.
No big surprise
So
there.
regarding the charge. So we'll start,
In reviewing this motion, the judge must view the case in the light most favorable to the Commonwealth. That is the standard, and based on that, she finds that she's going to deny the motion. We're not surprised. But do you think that Brennan scripted that for Lally, because it was a ridiculous argument? I think even Adam Lally could have came up with a better argument than that. But here we are. Now we're going to talk about the proposed jury instructions, and we're moving on.
with the, all right, so regarding the charge.
We're going to talk about the missing witness
So we'll
charge, among other
start
things.
with the defendant's
Here it is.
missing witness request. Who's arguing that motion?
We're not arguing that, Your Honor. And I apologize, but we made the decision last night to withdraw 2 of our requested instructions, which would shorten things today, I think.
Oh, okay, so everything on this is done, right? The defendant's motion to present a missing witness argument and request for instruction, you're withdrawing that?
With regard to the absent witness instruction, we're withdrawing that request.
Okay. And what else from your proposed instructions?
Okay, let me just, I know you're going to be confused by that, so let me just explain that to you. The defense had asked for a missing witness charge, a missing witness charge to, and we went over it at length the other day, but in brief, this is what it means. You can ask the judge to instruct the jury that because the Commonwealth did not call Michael Proctor, Brian Higgins, and Brian Albert to the stand, you, the jury, may infer that those witnesses would have testified in ways that would be harmful to the Commonwealth. Therefore, you are allowed to draw that inference from the Commonwealth's failure to call these witnesses that are under their control because they would be bad for their case. We went over that motion at length. We discussed it at length. And now David Yannetti has just said we are withdrawing that. We don't need that. Because they still will be allowed to argue in their closing the same exact ideas. Look, they didn't call Michael Proctor. Why? Why didn't they call Michael Proctor? He's the lead investigator. Why are they hiding him from you? She doesn't need to instruct. They say, we don't need you to instruct the jury that they can draw a negative inference is from that, because I think that they are going to just argue that in closing. And why fight about it now? They don't need the instruction because maybe that is something that is so obvious that a jury will pick up on. Yeah, why didn't they call Michael Proctor, their lead investigator? He was fired because of his bias in this case. Why didn't they call Brian Higgins after, he was clearly ghosted? He has motive. They're going to be still allowed to argue that stuff in closing. They're just dropping their request for that charge to the jury. Okay, moving on to the next.
You said there were two. What's the second one?
The second one is that there's an entry on our request for lost or destroyed evidence where we're withdrawing that.
Okay, I had a question about that. All
They're
right.
withdrawing lost or destroyed evidence as well.
There is a supplemental instruction that we're asking the court to give regarding the display of the sweatshirt.
Oh, that's right. I saw it on email. I don't have a hard copy of it.
That's Mr. Alessi's.
Your Honor, if it's helpful to Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and come back to that after I've read it, okay? Who's arguing for the rest of the defendant's proposed instructions?
I am, Your Honor.
Okay, so we're gonna go through them one at a time. Who's arguing for the Commonwealth? Okay, so I think you're sort of in agreement on the basis of the law, right?
Yes.
All right, so model homicide instructions, and just as last time. So that takes a lot of time out of today.
The only thing I would draw the court's attention, the Commonwealth does have a request for, and I understand what the court's position might be on this, but as far as the instruction related to murder charge, the Commonwealth is only seeking an instruction on murder problem.
All right, so we will deal with that.
We discussed that as
I'm
well.
going to go through the defendant's instructions, or sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So presumption of innocence, I think
All right. So we went over this the other day at length, but we're going to go over it again in case you missed it. The proper jury instruction for the charges here on murder in the second degree are that murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, the defendant caused the death of John O'Keefe. 2, and this is where they changed their request here, the Commonwealth. The defendant intended to kill John O'Keefe. They want that stricken. They don't want that as part of the instruction. B, the defendant intended to cause grievous bodily harm to John O'Keefe. They don't want the jury instructed on that. Shockingly, the only thing they want the jury to be instructed on with regard to second degree murder is the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. They are abandoning Karen intentionally killing John, and they are abandoning that she intended to cause him grievous bodily harm. And the only thing they want the jury to be instructed on is that she intended to do an act, the act of going in reverse however many miles an hour they're saying she went now, and that she knew that if she did that, that he was back there and that she could have caused his death. We went over that the other day, which in my opinion was kind of waving the white flag as well, which added to the fact that they've now dropped their rebuttal case makes me think that I was on the right track there. And that's what Alan Mullally just said. We don't want you to charge A and B, just C. Or not 1 and 2, just 3. I forget what he just said. Okay, moving on. It sounds like manslaughter, but not murder, but the manslaughter charge is different. That's the second degree murder charge, okay? So we will move on and see what else they say. And if we have questions at the end, I've got all the papers here. We can talk about them more at length.
presumption of innocence is a little more robust than what you, presumption of innocence, to go through those, and then we'll have the argument on that. So presumption of innocence, I think my presumption of innocence is a little more robust than what you've requested, so I will probably, okay. And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction proposed on page 4, reaching a verdict. Just, I will make it crystal clear, though. I think it was, and I was upheld on it, so I will make it.
Okay, Your Honor. Now we're getting to the verdict slips, okay? I think it was crystal clear during the first trial, and I was upheld on it. Meaning it went up on appeal to like a million different appellate courts, including the US Supreme Court, who decided not to hear it. And I was upheld on that. So I'm pretty confident that my instruction about your verdict, reaching a verdict, I'm pretty sure my charge was good enough last time, but I've strengthened it this time. Because remember what happened last time. She gave them 3 different verdict slips for the 3 different verdicts. First one was on second-degree murder. The second one was on manslaughter. The third one was on not leaving the scene of an accident causing personal injury or death. And she told the jury, do not come back to me until you have reached a unanimous verdict on all 3 of the charges, and do not fill out any of the paperwork until you are unanimous on all 3 charges. What happened after that? They didn't fill out any of the papers. They said they were deadlocked. She eventually granted a mistrial. And then after the mistrial, the jurors started contacting the defense and the prosecution saying, wait a second, we acquitted her on the murder charge and we acquitted her on the leaving the scene of the accident charge, but you told us not to fill out any papers until we agreed on everything. So that's what we did. And here she is in front of the world saying, I think I did it well enough last time, but I'm going to strengthen it just in case. Because double jeopardy in Massachusetts doesn't seem to exist. Listen to that again.
Indictment. I'll give each individual indictment. I'll give some further language on that. You've got an instruction to propose on page 4, reaching a verdict. I will make it crystal clear, though. I think it was, and I was upheld on it, so I will make it crystal clear. Okay?
I was upheld on it.
So I'll give you that, Ms. Giannetti. What is evidence? I probably won't give.
I'll give you that, Mr. Giannetti. Like it's a putt in a match play. I'll give you that. You don't need to putt it out. I'll give it to you. She's unbelievable.
Verbatim what you have, I'll take a look at it, but I will certainly cover all these topics. So, Ms. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction?
Yes, please, Your Honor.
Again, if you want to take a look at what I gave last year, I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give you Bowden. I'm going to take a look, size this up with what I gave last year. I gave Bowden last year. I gave a Bowden instruction. I don't think the Commonwealth objects, right?
We would object to the instructions.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to the Bowden.
A Bowden instruction says, and we'll read it in its entirety later, that the investigation was so poor that there's no way that you could find her guilty. And it's laughable that Adam Lally is going to argue against it, saying that it was a great investigation. I can't wait to hear what he's got to say about this. Lally is talking because Brennan is off. Oh, Brennan is actually sitting there. That's a great point. I figured Brennan was off preparing his closing like Alan Jackson is, but no, Brennan's sitting right there. Maybe he's embarrassed. He doesn't want to get up anymore. He's like, you do this, Lally. I'm done here. I'm collecting my paycheck and leaving. I'm grabbing my toys and getting out of this sandbox, leaving skid marks. But now I see that he's sitting there. Okay, let's see what he says.
I gave Bowden last year. I gave a Bowden instruction. I don't think the Commonwealth objects, right?
We would object to the instructions.
Okay.
Of course we object.
Go ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to the Bowden, and I would incorporate, and I know there's no request for instruction for third-party culprit, but the Commonwealth would be making similar requests that counsel be prohibited from making a third-party culprit or Bowden argument.
Or Bowden? Or Bowden?
I'm sorry?
You don't think the defense should be allowed to make a Bowden to argue Bowden?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either Bowden or third party culprit in this trial has come from questions from the defense, not from actual evidence in the case, not from testimony from witnesses from the stand.
That is because the judge denied them an expert on police procedure and told them the only way that they could get out the evidence that the investigation was bad would be to cross-examine the Commonwealth witnesses who obviously did not want to admit how bad their investigation was. This is humorous, this argument.
Not from actual evidence in the case. Any testimony or evidence related to either Bowden or third party culprit in this trial has come from questions from the defense, not from actual evidence in the case, not from testimony from witnesses from the stand, exhibits that have been put into evidence, or anything of the like. So in the instruction and arguments are based or predicated in the case law on evidence. Not, and obviously, as the court is well aware, there's a specific instruction that no matter how powerful they are, questions to counsel are not evidence. So what the Commonwealth would submit is if the court looks at what is actually in evidence in this case, there is no basis whatsoever for not only a Bowden or third party instruction, but specifically for even counsel to make that argument during the course of the closing. And I understand Bowden is a little bit more loose as far as the court certainly.
So I'm going to ask Ms. Giannetti to explain to me. All right, so I disagree with you on Bowden, but I'll take a closer look at it. Ms. Giannetti, what is the Bowden evidence that warrants an instruction?
Lally-flop,
I
lally-flop.
think it's multifaceted, Your Honor. The police did not secure the crime scene.
All right, do you want to hear the Bowden instruction before we hear him argue? I think that's probably the best way to do that. Let me read this to you. It's probably not going to be a long day in court, so we have some time. Here's the Bowden instruction, and this is what they want. It's short, so I'll read it to you. And this is what Lally says they shouldn't have. You have heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted tests or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the tests or other actions. If you find that any omissions in the investigation were significantly and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you, and you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. That's the Bowden instruction. Lally says that they shouldn't get it. Here's King David on why they should.
What is the Bowden evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate material to pack the evidence. Chain of custody was contaminated and corrupted. There was evidence of the bias of the investigator, failure to pursue other suspects, specifically telling his friends that the homeowner was sacrosanct because he's a Boston cop too. There was just a focus on Ms. Reed to the exclusion of everybody else. It was not an open-ended investigation. From day one, it was focused on one person and one person only. And just responding briefly to Mr. Lally's comments about how he didn't introduce affirmative evidence of the proper way to do an investigation. We tried, Your Honor, we made a motion and renewed it, asking for reconsideration of the court's ruling that Mike Easter could not testify about an investigation. So to say that we didn't introduce that evidence when we tried to do it when we were
I think what Mr. Lally was saying, that you asked questions but weren't given answers. And so I think that's what was said. I'm going to, Mr. Yannetti, I'm going to allow you to argue Bowden, and I am going to give an instruction. So third-party culprit's an entirely different animal here.
They
I
didn't
know.
ask for it.
But tell me, are you going to argue it? Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to investigate whether Brian Higgins did.
Okay, so just so that it's clear, that you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert. So that was separate. But I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that. Not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, Your Honor, and we're strictly going with a Bowden defense.
Okay, so you can get into third-party culprit with Brian Higgins, that
Wow.
the police were aware of whatever you're going to argue and failed to act on it. But it's strictly for that purpose, okay?
Yeah, I understand. That's crystal clear, Judge.
Okay.
And that's really what I was seeking, was clarification based on
Yeah. So Mr. Yannetti, and of course I take him at his word, tells me that they're not.
This is where we got that from. Look at the closed captions. Misty and Eddie. I wonder if Lally's doing the closing. Wouldn't that be a turn of events? We talked about yesterday about all of the ethical violations that, in my opinion, Hank Brennan may have committed during the course of his persecution of Karen Reed and his duties as, specially appointed assistant district attorney. But yeah, I'm throwing Higgins under the bus. Brian Albert is protected. The Alberts are protected. I mean, it's pretty damn obvious now. Keep my friend's name out your mouth. Says Mandaro. Here you go. Watch the captions. Misty and Eddie.
Yeah. So Misty and Eddie, and of course I take him at his word, tells me that they're not going to do pure third-party culprit. Okay, that's great. That makes that easier. So I will give, sure, go ahead.
While we're on page 8, I just wanted to, Alma does have an objection to the Batista instruction that's at the top of page 8.
Yeah, I have a check mark next to that. Ms. Giannetti, tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
Right. So, obviously it's not the strongest DG Batista argument that we would have. It does not occur at a police station. But, these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on your own cell phone. It could have been done. It wasn't done. We had to rely on police memory of what my client.
I know you're having a hard time hearing him, so I'm going to read the instruction to you quickly. It's one paragraph, and this is what they're arguing about now. It's an instruction that says, you may also consider the absence of a complete recording of the defendant's statement. The absence of a recording permits but does not compel you to conclude that the Commonwealth has failed to prove voluntariness beyond a reasonable doubt, meaning the statement that she gave to Yuri and Michael Proctor when they came to her parents' house in Dighton. And we've looked at other investigations by these same officers in other cases in the area, including Brian Walsh, Harry Turk, and all of those statements were recorded. And Dr. Turk, that was in 2020. Brian Walsh was in 2023. But they know how to record statements, and it is something that they do as a matter of course. In fact, when Brian Walsh was interrogated by police, he was in the hospital. He had just come out of an alcoholic or some sort of alcohol-induced coma, and his interview was something like 3 hours long, and it was recorded in the hospital in a conference room. So they know how to do it. They didn't do it, and I think they should be allowed to argue it. But let's hear what she's got to say about that. I'm going to take it back to the beginning of his argument, and I find it better to do this in real time. So if you're bothered that I stop what they're arguing to explain it to you. I just find it makes more sense in real time to do it that way. And so that's the way I like to do it.
Longest, did you,
Its house.
right, so,
Okay, wait. So
They
she's
should have recorded. Tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
right, so, obviously it's not the strongest DG Batista argument that we would have, does not occur at a police station, but, these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on your own cell phone. It could have been done, it wasn't done. We had to rely on police memory of what my client said or didn't say when there was a possibility for a recording, so we still think we're entitled to the.
Do you think it was custodial interrogation? Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was a custodial interrogation.
they took her phone and her car without warrants. She wasn't technically under arrest, but clearly they made it known that she was they wanted her devices, let's say.
We had police officers who, refused to sit down in the living room. They were surrounded with her. Someone who was not familiar with dealing with the police at all. So yes, I think there's an argument that it could be considered custodial.
All right, what do you say about all this, Mr. Howell?
And I would also add, Your Honor,
Sure.
they did seize her vehicle.
Oh, thank you.
Around the same time. So, that it
And her phone.
goes to the issue of custody and my client being able to deny it.
All right. What do you say?
That's the very nature of the objection, Your Honor, is the non-custodial nature of this. So the trooper spoke to Ms. Reed at her parents' house, as they did with a number of different witnesses on that day as well, throughout the course of that day. They spoke to her while she was seated on the couch in her parents' living room. The parents were present, no one was restricted from being. And it did not end in any sort of custodial situation. She was taken into custody, she wasn't arrested. Yes, they did seize her cell phone and her vehicle based on information that they had developed over the course of the day and from the statements from Ms. Reed herself. But I don't think that transforms that conversation or interview in her parents' living room into a custodial interrogation. The bigger issue that I have placement, as far as there's already been within the same requested jury instructions or requested humane practice, and then following the DAG and Batista language in the defendant's requested jury instructions, there goes on to all of this other requests regarding her compromised mental state and all of these other things that, while if it were to be given by the court, should be given in the same context of humane practice. I don't think it's something that should be highlighted in two different sections. And I would submit that there is no evidence of her having a compromised mental state or anything to that effect. She exercised her judgment as far as when she was speaking with Sergeant Lieutenant and having testimony from the stand, that initially she said she was fine with answering questions, but didn't want to get into any details. And then when the questions became centered on, or more centered on details, at that point, and I know that's not in the jury, but of course, well aware, she then ended the questioning at that point. So I don't think there's any evidence of her having a compromised mental state during the course of this interview, and I don't think that arises to the level of the DAG instruction. So I would ask basically that everything on page 8 prior to the vote instruction be excised.
All right. I'll take another look at this and I'll just let you know in the morning.
And, Your Honor, with regard to the compromised mental state, we agree that that would not apply to the interview at your residence. But we believe that it applies within the humane practice context.
That is where it makes sense. So, all right.
If it's going to happen, it should happen once, not.
Yeah.
I think that's fair.
Okay. Okay.
Here's the charge on compromised mental state, and I tend to disagree on this. So that charge says, if there is evidence of the defendant having a comprised mental state, you must take special care in determining whether any statement was the product of the defendant's rational intellect and free will. Number one, she was in an acute grief state, having just found her boyfriend of 2 years dead on the lawn of Brian Albert. Number two, she had just been released from the hospital on a section hold, an involuntary hold, because there had been statements that she perhaps intended to, she may have wanted to take her own life. And who knows, she was medicated at the hospital, I'm sure. But David Yannetti is saying that he's willing to waive that one in exchange for the other one, which is, I will find that and we will talk about it as soon as I find it in there. Their charges are 37 pages. So let's keep going.
All right. Prior statements, I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is withdrawn, so is the,
Not to interrupt.
That's okay.
I am interrupting.
that's okay.
With regard to the view, Your Honor, we did include a language reinforcing the fact that the rock that they saw on the view
Oh.
was not present on January 29th. We asked the court to repeat that one sentence.
Okay.
Yeah, they want an instruction that the rock was not present. That rock that was there when the jury went to the 34 Fairview. We want an instruction saying that the rock was not there on January 29th of 2022. It was a big rock that said Albert's painted on it in like finger paint. And it just magically appeared the day that the jury went to visit 34 Fairview. They want that one sentence added to the jury charges as well.
Okay. So I did not see this when I took a quick look at the view. All right. I'm not going to repeat it.
She's not going to repeat it? That's bullshit. Oh, I'm sorry. That's bullshit. Hang on. I'm going to find it for you now because now I'm mad and I'm going to start with the bullshit button already. Sorry. Sorry, nail salons and doctor's offices. If I'm playing on your TV, I'll try not to say it again. But we're going to go back to that right now. That is they didn't number their charges and that's making it difficult for me. And they're also not talking. They didn't say what page it's on, but hang on a second. This is important. She's not going to repeat it. Did somebody say yesterday that you heard her tell them that they cannot bring their notes to deliberate? Because usually they can, so that's interesting to me. Hold on, just give me a sec. Talk to yourself. Talk amongst yourselves. Okay, here's the charge on the view. This is what I also call a field trip. They went on a field trip to 34 Fairview right at the beginning of the trial. And here is the instruction that the defense wants. You'll remember that we took a view in this case. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. You may recall I gave you an earlier instruction about a rock that was in the front yard of 34 Fairview Road. I remind you again that the rock has nothing to do with this case and was not there on January 29th of 2022. And she is saying she is not willing to say that as part of the jury instructions. And I don't think that is fair. I think that she should say that again. But again, here we go. Upside down, inside out Narnia. Dictatorship of Norfolk County. Let me know what you think.
All right.
She just said, I'm not going to give it. Hold on.
The fact that the rock that they saw on the view
Oh.
was not present on January 29th. We asked the court to repeat that one sentence.
Okay. So I did not see this when I took a quick look at the view.
Maybe you should
I'm
read it
not
more
going
carefully.
to repeat it.
Maybe you should read it a little more carefully.
All right. Lost or destroyed evidence you're withdrawing.
Yes.
Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, even the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
If I might just in reference to that.
Sure.
Only language in there I would object to it.
Okay.
Testimony of a police officer or someone else who works for a law enforcement agency.
What do you mean by that?
Here's the instruction for law enforcement witness instruction. You should evaluate the testimony of a police officer or someone else who works for a law enforcement agency in the same way you would evaluate anyone's testimony. You must not automatically believe or disbelieve a witness just because the person is a police officer. Adam Lally has a problem with the portion that says, or someone else who works for a law enforcement agency. Here's his problem.
I think that was taken into account for the dispatcher, perhaps. We're not.
I'll do police officer because they're police testimony. I'm not going to go beyond that.
I think that might be possible.
Okay, thank you. I'll do the photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I will give, I'll cover all those topics. What page you on? Okay.
All right, here's the instruction on juror notes. Many of you have taken notes during the trial. Your notes may help you remember the evidence, especially the testimony, but of course they are not an actual transcript or official record of what was said. So use your notes only to help you remember what you heard and saw during the trial. Whether you took notes or not, you must rely on your own memory of what the witnesses told you. After the trial is over and you have returned your verdict, a court officer will collect your notes and destroy them. So that indicates to me that they can bring their notes backstage with them when they deliberate. I'm not sure why everyone in the chat yesterday was saying that she said that you couldn't bring your notes. Maybe it was hard to hear and people were misheard her. Okay, moving on. Glad we cleared that up.
What page you on? Okay.
One suggestion there was indicates now the Commonwealth has introduced photographs and evidence. I would submit.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your objection?
I actually think the defense has introduced more graphic.
Yeah, so I would just say you've seen photographs. Or there were photographs in evidence. I instructed twice anyway, maybe 3 times on it. So I'll give some version of that. Juror notes, I'll give some.
Here's the instruction on photographs. Now the Commonwealth has introduced photographs into evidence. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one way based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. And Lally wants stricken the part about the photos being graphic and unpleasant. Defense seems okay with that. And the judge said, I've already instructed them about graphic photographs. I don't need to put the graphic part in there again. Okay, moving on.
Some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right, so the Commonwealth's requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally. So let's skip to it's not numbered, your supplemental instructions, use of a dangerous weapon.
Yes.
All right, so I'm going to give that, Ms. Gianetti. I gave a dangerous weapon instruction last year on the motor vehicle.
Understood.
All right, so I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence. Evaluating the evidence, there's some instruction. Ms. Gianetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine.
Let's talk about the dangerous weapon instruction. Hold on. Let me just put that over here on this screen. Give me a moment. All right. I'll just have to read it from here. Use of a dangerous weapon, motor vehicle. As a general rule, you are permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, right? But that's going to be stricken. The intent or cause him bodily harm. It's just going to say, and I hope they catch this. As a general rule, you are permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to do an act which, in the circumstances known to him, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. And she said she's going to allow that. She gave it last year. She's going to give it again.
Ms. Giannetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks. And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find, or something, preface it. Witnesses when, the attorneys interviewed witnesses when preparing for and during the course of the trial.
No objection.
You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate, though, where it says during trial, during the course of the trial. I'll just say when preparing for trial.
Yeah, we're joining in the request. I don't know that we included that in our instructions, but we're joining in the Commonwealth's request for that instruction.
All right. Okay. Expert witnesses, electronic communication. So I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The emotional impact photos, humane practice. We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction before that testimony.
But Aruba didn't come in. Let's just go over quickly the humane practice instruction. You have heard testimony about a statement allegedly made by the defendant concerning the offense which is charged in this case. Before you may consider any such statement, you are going to have to make a preliminary determination whether it can be considered as evidence or not. You may not consider any such statement in your deliberations unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she is alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. And I think that's going to go to not only the interviews, but anything that Yuri Buchanan said that Karen told him during that interview at her parents' house in Dighton. Refresh my recollection, chat, because we're so collaborative here. Did they play the video this year of Karen being brought in after she was arrested for the second time? And it was Yuri Buchanan's body cam of Karen saying we're all in on the same joke. John was pulverized and my taillight was cracked. Brian Albert and Colin Albert beat the bejesus out of John. No, they never played that, right? That's interesting. And I think maybe it's because they were not allowed to point to Colin Albert as a third-party culprit, and that's why they never played. But I thought that would be fantastic for Karen. We're all in on the same joke, right? John was pulverized and my taillight was cracked, and they could have brought that in through Yuri. I don't know why they didn't do that. They could have cut out the part about Colin, right? Because I don't think she mentioned Colin in that video until the end. Interesting. All right. Taking this back.
Instruction. I did that in to. We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction
Nobody asked
before
for it
that
here.
testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
Nobody asked for that.
Your Honor, with regard to Aruba, we don't believe that there was really any guilty that came in.
I thought it came in through Kaylee. I should say it did come in through Kaylee.
Oh, we didn't hear Kaylee.
That's when I get
Kaylee is the niece. The cameras were shut off for her testimony. And now she's going to say that she's going to allow that instruction because Kaylee said they had a fight in Aruba. This is why I don't like them using the children. They were using the children for nefarious purposes. We really don't know what her testimony was because none of the news reports that I looked at regarding Kaylee's testimony, because the cameras were off, were complete. So we really don't know what Kaylee testified to in a complete fashion because nobody accurately reported on it. Just like yesterday, they were all reporting that the defense had rested and the defense has not rested. Well, I can't trust anything anybody says or on that side. That's why they used the kids. All right, I'm going to hear it again. I want to hear that again. I know it's hard to hear, but try and use the closed captions if you can.
give on this Aruba incident. And I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction before that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
And here's where she's going a little outside the lanes here, because neither side had, even the Commonwealth has not asked for a prior bad acts instruction or a state of mind of John O'Keefe instruction. She's going sua sponte here, and she's like, yeah, I'm just going to do it. I'm just going to do it. I mean, she's got the authority to do it, but some may consider it improper. Okay. Mommy giving a little help again to the Commonwealth, being that maybe she knows they tanked their case.
Your Honor, with regard to Aruba, we don't believe that there was really any guilty that came in.
I thought it came in through Kaylee. I should say it did come in through Kaylee. That's when I gave the prior bad acts instruction. She testified. Okay. All right. So did I give it any other time that there's another event that I should highlight? I don't
Highlight anything for
so.
the Commonwealth.
was an instruction at that time.
All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right, those were the limiting instructions I wanted to get to. So,
We would object to the part of that act being linked to the Higgins text message.
all right, I'm going to take a look at that, Mr. Lessie. All right. Consciousness of guilt.
Your Honor, Collins.
Okay. All right.
They're withdrawing there?
All right. So tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
Your Honor, so the only,
1 second, let me just pull that up.
We just went over that. So they
Okay.
only, okay. hold
Your
on.
Honor, Collins' request is merely not for any change or alteration in the instructions that were given, other than there are 3 prongs of malice, and essentially the Commonwealth is requesting is that the jury be instructed
Speak up.
merely on 3rd prong malice, as that's the only one that really applies to these factors. So
Okay.
the Commonwealth here, the first 2 prongs are essentially extraneous in this situation, and you don't see expectation of the jury. To avoid confusion.
Do you have supportive case law for me to single this out?
What? He wants,
What do you say, Ms. Giannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to do him grievous bodily harm, not intent to kill him. And it was just the 3rd prong. He stated that in his opening. I imagine that's what he'll likely argue in his closing. You know, I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I could say the parties agree that the 1st prong and the 2nd prong are not applicable here.
he's deferring to Karen on this, on the Leslie.
I think we're just at a position where we'll defer to the court on this.
Well, I'm not going to say you agree if there's no agreement.
Yeah, I think she should say
You
the
can get me a
Commonwealth.
case by this afternoon.
It's always the
I will
case.
endeavor to do so, Your Honor. We will, I don't have anything.
I'm inclined to go with the model.
Really? Gives the jury too much to do.
I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support the position that it's just the 3rd prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
And that's really the only reason for this. But I understand, and I don't certainly want to take.
You know, I suppose I could always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply, maybe.
I wouldn't mind.
We wouldn't have an objection to that.
Maybe I'll do that, but let me see if I can find something. If I can find something that says I don't have to give those first 2 prongs, I'll let you know before you begin. All right.
And Your Honor, before the court makes a decision on that, we see what the court is proposing if you are going to alter the penalty.
If I alter it, it means I remove those 2. That's all.
But no, we just want to.
Yeah, sure. My guess is that won't happen. but we can see. All right, so lesser included offenses. Did you want an OUI instruction? You were,
We're asking for that.
okay. All right. Right, I think that's it, aside from Mr. Alessi's motion regarding the exhibit. Right, is there anything else that we're missing?
Just a couple of other issues. One is with regard to the Proctor text messages, we have a redacted version now, which we'd like to submit to the court of the Commonwealth. You recall that we had agreed essentially on a redaction subject to the court's ruling.
Okay,
But it wasn't in final form. We believe it's in final form now.
and you all agree that it's in final form?
Well, they haven't seen it.
Oh,
But I'm going to
okay.
give it to them now. Can I hand this to the court?
Sure, thank you. All right, so.
The only other issue, Your Honor, is we do have a...
Hold on one second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it. And I'd prefer not to have to deal with it, so.
I'm sure we can be in touch this afternoon. I do not believe there's going to be any problem with this.
Okay.
Just a couple other things before we get to Mr. Alessi.
Yeah.
One is that we do have the Dr. Wolf PowerPoint to be introduced to the evidence from.
Dr. Wolf or Dr. Rentschler?
Dr. Wolf.
All right. And this was allowed into evidence unobjected to. I thought we already had it. We didn't?
We have them redacted, so we
Okay.
redacted. It's on a thumb drive.
Okay. And the Commonwealth has seen it? All right. So they'll have to see it. So Mr. Lally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
And then, will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
Thank you.
All right.
And I think I did mention that we had a proposed verdict slip for count two, Your Honor, if I didn't.
You did not.
Okay, we do have one, we've got given a copy to the Commonwealth. Can I hand
Okay.
the proposed copy to the court?
Sure. Is it the same as last year's, but now with a?
It's different.
Okay. All right.
So you'll have a chance to digest that.
Oh, I digested it, Mr. Alessi. Go ahead, I'll hear you.
I'm actually Yannetti.
Yannetti, jeez, I'm sorry.
So, Your Honor, you'll recall.
Keeps calling him Mr. Alessi. I just put a poll up in the chat, and the poll is, what will the jury do? Not guilty on all charges, guilty of second-degree murder, guilty of manslaughter, hung jury, meaning they won't agree, and it will be a mistrial. I can only have 4 choices on a YouTube poll, so there are something like 21,000 of you here and change. I would like to get some big numbers on this poll, so if you wouldn't mind taking a moment, just casting a vote on that poll so we can get a good sampling of what you think the jury will do in this chat. I just want to take this back one question because I was drafting the poll and couldn't exactly hear what they said. Here we go.
Okay. All right.
So you'll have a chance to digest that.
Oh, I digested it, Mr. Alessi. Go ahead, I'll hear you.
I'm actually Yannetti.
Yannetti, jeez, I'm
I'm
sorry.
actually Yannetti.
So, Your Honor, you'll recall we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser includeds and the number of...
Okay, he's arguing for more than an hour in closing. Did she just say she would only give them an hour and 15 minutes? Sorry, I didn't take it back far enough.
believe I've given a copy to the Commonwealth.
Uh,
I did mention that we had a proposed verdict slip for count 2, Your Honor.
Proposed
You
verdict
did
slip.
not.
Okay, we do have one, I believe I've given a copy to the Commonwealth. Can I hand the
Okay.
proposed copy to the board?
Sure. Is it the same as last year's, but now with a,
It's different.
With a box for not guilty? Imagine.
okay. All right.
So you'll have a chance to digest that.
Oh, I digested it, Mr. Alessi. Go ahead, I'll hear you.
I'm actually an Atty.
Yannetti, jeez, I'm sorry.
So, Your Honor, you'll recall, we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser includeds and the number of elements that are different for each lesser included. And we were uncomfortable with, there being one option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
the analysis is over. If it's a not guilty verdict, they go on to the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the lessest, or the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty. We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least, looks like three of the charges, including the main charge, because there's this issue of either under the influence or 0.08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clear, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, as a
This must be a new motion that was filed today. It has not been scanned into the system yet, so I can't read it to you. But they're arguing about the verdict slips, and they want to make sure that this time the jury understands them and that they are clear, because they were hella confusing last time.
The board is probably well aware the Commonwealth not requesting any lesser included, and I certainly understand that if the evidence supports it, the defense requests it, that the court must give it. Having said that, the verdict slip that was used in this matter last year, the Commonwealth Smith is more than sufficient adapted to the defendant's request. The only other thing I would bring to the board's attention, I don't know if Ron is aware, there was a case recently, while this case was going on, tried before Judge Rebuttal, in
Yes.
which he had similar issues, and I believe used at least part of the verdict slip from the first trial, in this case, as sort of a template for the lesser included that he instructed and the verdict slip.
He's talking about the Judge Halal case that was tried while this was going on, and that was the Turk trial. We watched that together. That's Judge Halal, that he used your verdict slip and it was okay. Okay.
They utilized an act. I don't have a copy of it on me, but I can certainly get the court a copy of it.
She's not going to defer to another judge.
That may be somewhat helpful with the court's thinking.
Okay, was that on murder case?
It was not, but it had to do with a felony motor vehicle homicide.
Oh, okay. So it's not the Turk
I'll
trial.
take-
Felony motor vehicle homicide. Look at Kathy's here from Gossip Rumor and Innuendo. Thanks for gifting 5 memberships. And if you don't follow Kathy, Gossip Rumor and Innuendo, you should go over to her YouTube channel and give her a sub. She's hilarious. She's hilarious. Every morning she drops it like a 20-minute video of all the funny things. Well, she makes it funny. She tries to make us laugh about the true crime cases and trials that are going on here. She's never going to defer to Judge Halal on anything. She is the queen bee. Oh, there's another name for her, Queen Bee. She's not my queen.
Take a look at it. Mr. Turk. Mr. Turk. Mr. Yannetti.
Margaret is saying Mr. Turk. Okay, this is Margaret. She's the court clerk today because Jim must be sick. He's been coughing throughout the whole damn trial. Or, you know, he had a scheduled day off or something. Margaret was the clerk in the Turk trial. She's amazing. We love Margaret. She showed all the bingo balls before she picked the alternates. And she's just asking Lally if it's Mr. Turk because she's going to pull it up right then and there because this woman is a workhorse. She's amazing. We love Margaret. Wonder if she'll be there for the rest of this trial. That would be amazing. Although Turk was not a motor vehicle homicide, Turk was a strangling. Harry Turk murdered his wife, Katie McLean, and he was only convicted of the least charge, manslaughter. He was represented by Kevin Reddington, who also represented Jennifer McCabe during the course of this trial. I think that's what she just said to him. Hold on.
Not that it had to do with a felony motor vehicle homicide.
Yeah, I'll take a look at it. Mr. Turk. Mr. Turk. Mr. Yannetti. I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Wells is an excellent judge. We think that this verdict slip is, it provides the most clarity for the jury. That's why we're.
Okay, and that's where I think we disagree. So I will take a closer look at that.
Dude,
and
you got taken up to the highest court in the land of Massachusetts, and then you got taken into federal court on your verdicts. Well, they didn't really argue the verdict slip. It was double jeopardy more, but they should have argued the verdict slip. And it went all the way up to SCOTUS, and they declined to hear it. But you're just going to still do the same thing you did last time? Remember last time she forgot to put, or she didn't allow them to put a box in there for not guilty? And she said, well, if they just don't check off guilty, that means not guilty, right? I don't know. Even the slips are incestuous. We'll see. I haven't seen the papers because they're not scanned in yet.
so has it been filed officially and docketed?
I just handed it, I believe.
All right, so Madam Clerk, you have a copy up there?
The proposed, I think this is the only copy.
Okay, that's what I was wondering, okay.
Do you need an extra copy?
Sure.
This is the,
Yes. Or, you know what, just mark it for identification, Margaret. We'll do that. Chrissy, please. Just for ID.
it's LLLL for ID.
Thank you. Mr. Lally.
Your Honor, just one request, circling back to the constitutional instructions. So the Commonwealth is withdrawing its request for the instruction.
Okay.
However, would be seeking to make some argument or reference in these arguments to the jury related to specific areas which we would need conditional approval before we did. So the two areas that are there, so this is within that we would like to make some argument to the jury regarding is the defendant's taking of the Lexus from one metal head
No.
to her parents' residence indictment, and then certain statements made in reference from the various clips of the play of her statements.
Okay.
In particular, would be the one where essentially she says there's a certificate to her.
Okay.
Whatever the exact.
All right. Mr. Yannetti, do you want to weigh in on that?
Yes, really.
Misty and Eddie. I thought it was too good to be true when Lally says that he was going to withdraw their consciousness of guilt jury instruction. I thought that was too good to be true because they played all of those clips.
Objective to that, I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of to another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. In fact, when the police call, she says, yes, come on over. I don't see that as being any evidence of consciousness of guilt.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
And just to be further clear, there may be other criticisms.
Yes, so I did want to ask you, though, Ms. Giannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those.
She never should have
Are
given
you
those
sure you
interviews.
don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well?
No, we
Okay.
do not like it.
Okay, I just wanted to give you the opportunity. Okay. All right, anything else? Anything else, Mr. Yannetti? We're going to hear from Mr. Alessi, but
The Commonwealth does not object to the redactions.
that's great. Thank you.
Oh, Miss
One
Melissa
less thing you all have to do today.
found
Okay.
her voice.
I know. All right, so let's make that, are we switching that new redacted version with an exhibit number? Do we know what it was before? Excuse me? The redactions on the Higgins messages, that's what you're saying you're fine with, right?
Proctor Communications.
Proctor Communications, okay.
Right, this is the testimony that came in. from
Of
this
Proctor, I was, yes. All right, so we'll find the exhibit number and we'll just. 209, is everybody in agreement that it's exhibit 209?
Yes, sir.
Okay.
Does the court have a copy or do they need the Commonwealth?
No, I wrote on it. I need the Commonwealths.
So this is a clean copy. This one.
So that will now be 209 in evidence. You know what, can we make that 209A? We need, Mr. Yannetti, we need to keep record of the first one that was not redacted, so any objection to making this 209A?
No objection to that. And so original 209 will not be sent in. Is that?
It becomes.
So what do you think? Yeah. Yeah, so we'll switch it back to ID, and this will just be 209? All right, did we have an ID number on it originally? Can it still be that?
Is it redacted, the NNN, or is it, no, it can stay that.
Okay.
But is this the?
Oh, it's just NNN, it's not,
Well, where did it?
no, it became 209.
Yeah,
So that has to
our
be-
thinking is it needs to be sent back to letters for ID. I think
Yeah.
it's quite
So
important.
it'll be marked MM for ID.
That's great.
Perfect, and then the redacted version will now just.
209,
Yes.
yep.
So Proctor's messages will go back in with the jury for deliberations, minus some redactions, as well as Higgins' texts.
And we'll hear from you this afternoon. Just somebody send us an email to the clerk's office. So someone send an email to the clerk's office today letting us know if the Wolf PowerPoint is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Alessi, I'll hear you.
Thank you, Your Honor. If I might suggest respectfully a procedure to the court, I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to expedite this matter, if I might suggest to Your Honor to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and Introduction into Evidence of Exhibits. The exhibits is taken care of, that's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally could state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
So, Your Honor, Commonwealth's position is ultimately I defer to the court as far as whether or not it's an appropriate instruction to give in the final charge. What the Commonwealth would submit is that the contemporaneous instruction was more than sufficient to address the issue, and that it doesn't require any sort of differing language or further instruction given to the jury during the court's final charge.
Okay. All right, I'll hear you, Mr.
Thank you, Your
Alessi.
Honor. May I go to the podium?
Yes.
Thank you.
Thank you for finding a mic.
Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it are is Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why do we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly, but I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination, and challenging Dr. Wolf on several aspects. And this one was particularly apt. The subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis. And that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end, undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting too, and I emphasize cutting, and then he was cut off by Attorney Brennan, and Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note
Watch
that
that.
in the context of many other statements in this regard as to what happened.
And he had that shirt up there in the plexiglass sitting right next to the witness the entire day. Who got that exhibit for him out of the exhibit room and put it up there for him? I want to know. Was it Jim? Is that why Jim's not around right now? Because Alan Jackson was asked, oh, the judge even said, oh, Mr. Jackson, I assumed you knew that they were going to use the hoodie because it's been sitting here the whole day, right next to Dr. Wolf, Daniel Wolf, ARCA.
So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, so, jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't...
This is not an official transcript, right?
Exactly, Your Honor, so I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
2023.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury, therefore, should not weigh and value his opinion. This is very, very significant, and I underscore, Your Honor, we didn't cause this problem.
That's right.
We didn't cause any of this issue. So, to me, I do not understand why the Commonwealth would not support this. What we have written down here.
Yeah, Hank Brennan should want to save his own ass from not only serious ethical violations for intentionally misrepresenting to the jury, the world, the judge, and everyone how the holes on the back of that hoodie were made, he should want to save his own ass with regard to that alone. But also, in the interest of a fair trial, he knows that he did that. He knows he was wrong, and he should support this instruction wholeheartedly. And the fact that they don't, what does that tell you? They just don't care? He just doesn't care? I mind blown. Save his ass from getting disbarred. Somebody said save his ass from who? From getting disbarred. That's a major ethical violation. If he intentionally misrepresented something to the jury that he knew or should have known was not true, that those holes were made from the Lexus, from the alleged impact with the Lexus, and not by the MSP criminalist, that's a big problem for him. Anybody watch the Rust trial? I mean, Alec Baldwin?
The truth.
Hold on.
What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury, I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error, to me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred, that's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there, again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So, therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not objected to at the time it came in.
What?
That's my only comment.
What?
I will consider this. I'm going to hear from Mr. Lally.
What
I will
was-
consider this.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could just, thank you for raising that. 10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness.
That's right.
So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
Wow, she's a piece of work, man. She's a piece of work. We rewound that like 10 times. He goes behind the witness, Brennan. He picks up the plexiglass. Now he's got his back to his jury. He's close talking the witness, Dr. Daniel Wolf, Crash Daddy #1. He's showing him the back of the sweatshirt, not showing it to the jury or the defense team. And then he quickly puts it back in the little slot in between the judge's bench and the witness, and she's got the cojones to say, "Oh, you didn't object at the time." So, how many sidebars can they have? How many times can she do her exasperated sighing at the bench? So much so that we have an emoji for her sigh, heavy breathing into the mic. How many times can she apologize to the jury for going to sidebar? And now you can't use it as a shield and a sword, judge. You can't tell the jury, "Oh, I'm sorry about all these sidebars." Ugh, I know you guys are getting exhausted and we're wasting your time and all of that. I'm summarizing. And I say, "Well, you didn't object at the time. So, too bad." No. That is not how justice works. That is not how real honorable judges operate. And if you do not allow this instruction, I mean, if you weren't already convinced that the fix was in, the only saving grace here is going to be that 12 people that sit in the jury eventually, because 6 will be chosen as alternates, have actual common sense. But if you weren't sure that, the judge is completely biased towards the Commonwealth, and I've never said that before, but I'm beginning to change my mind. Harvey Weinstein just got a mistrial, by the way. Just now. Is that just now? Harvey Weinstein's sex crimes retrial ended with a hung jury on one count of rape in the 3rd degree today, after jurors were unable to convict. Manhattan Supreme Court Judge Curtis Farber ruled the deadlocked jury was not able to reach a verdict. And so it is hung. All right, well, there you go. Breaking news. Breaking news. We're here for all the news and all the things and stuff. See what Lally has to say for himself here. And it was Brennan who did this. So Brennan should be getting up to try and cover his own ass. So this is interesting that it's going to be Lally. Okay, let's go. No spoilers, please.
Yes, very briefly. I'm not going to get into a belabor the point as far as the back and forth about conduct of counsel. During the heat of trial, during the heat of the extended exchange with a witness on the stand, things can happen. Mistakes can be recognized, acknowledged, and accepted.
Things can happen, like lying to the jury, like asking Dr. Wolf if he considered all of the holes in the back of the sweatshirt that were obviously caused by the Lexus, showing Dr. Wolf, trying to show his incompetence in not considering that. Things happen. No, things do not happen, Lally. And were you more involved in this than the public knows, than we all know? Look at Brennan. Is he looking for a job on his computer? What is he doing there? Is he on Facebook? Is he on Twitter? Googling himself, seeing what people are saying about him online? Things just don't happen. That just does not happen. And you, Mr. Lally, who prosecuted the entire season 1, knew or should have known, as did the woman in yellow sitting next to you, Laura McLaughlin, who I think is a hell of a lot more involved than anybody's given her credit for. You knew Maureen Hartnett cut those holes in the back of that hoodie, and you sat there playing with paper clips. Things happen. No, things just don't happen. This does not happen in the real world. And so this argument is, again, DEFCON 5, it says. BS level DEFCON 5. God, tell us how things just happen and how Brennan apologized to the judge. Not really. Just said, "Oh, it was a mistake."
Recognize things can happen. Mistakes can be recognized, acknowledged, and
we acknowledged
accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in.
The curative instruction that she actually gave the jury was completely different from the one that they discussed and agreed on. Okay, we are in the Twilight Zone. We're in Narnia. We're in the Land of the Lost. And that's why Chaka is up in the corner, because he's from Land of the Lost. That was from an episode called Possessed. Chaka looks possessed, and we're all possessed by the devilish shenanigans that are going on in Norfolk County. We're in the Land of the Lost. It's official. You heard it, I heard it. They discussed a curative instruction. She gave something completely different, inadequate, and it was one sentence long.
There have been many instances were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel, was immediately remedied. It was taken care of.
I'm sorry, misstatement from the witness. Now you're going to blame it on Dr. Daniel Wolf, Crash Daddy number one. No, Mr. Lally. You do not come for Crash Daddy number one the way the Twitter trolls went after his wife. You don't do that. Odin's Martyrs pointing out the two witnesses that could have been crossed in rebuttal and asked what Hank knew about the x-ray and the sweatshirt were suddenly canceled. Coincidence? This is what you call cover your own ass, Brennan. Betterow made a great point on Twitter, and I think on Nurse Kim's show last night, and said he's covering his own ass now, and that's a conflict. Because now, if he canceled his rebuttal case because of things that could come out about him, that he failed to give Welcher the x-rays even though he knew that they existed, and perhaps some things Maureen Hartnett might say that implicate Brennan personally, that's a conflict for him. And now he's sacrificing the case on behalf of the Commonwealth for saving his own ass. That could be a problem. Tell me what you think. Odin's Martyr pointed it out perfectly. Listen to this. Whether it's from the witness. Yeah, let's blame it on Dr. Wolf.
Witness or the question from counsel. Misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel, was immediately remedied. It was taken care of. I don't think that there's any confusion by the jury. And furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
We don't want to accentuate it.
So I'll consider it, Mr. Alessi, okay?
Thank you, Your Honor.
All right. Anything else?
Consider it.
Two things I'd like to talk about for scheduling. The jurors get here early. I'm going to ask if the court officers to call the jurors and ask them two things. To ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45, ready to start. So things take a little while generally. That will assure us that closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask that counsel plan on just a half an hour lunch break. I'd like, the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch, you're free to stay in the building, and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least, hopefully, there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night.
Wow,
I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not let them start deliberating.
We have no objection to that. One request we have, Judge, is during the last trial, during deliberations, the court had asked us to be within 5 minutes of the courthouse. My office is about 10 minutes away.
I'm sure we can make accommodations for that. But at some point, we may have to talk about security issues. So a lot may depend on that.
Understood.
All right. Does the Commonwealth have any objection to that schedule?
No, Your Honor, none at all.
All right, so we'll see counsel in here no later than 8:30 tomorrow morning?
Sure.
We'll have counsel here at 8:30. All right, thank you.
All rise for the court, please.
Wow.
Is there already one of these, like, are we swapping?
Yes.
Goodbye.
Oh, good. I hope Margaret stays on. Do you guys love Margaret as much as I do? Hold on, I think they're done here, but yeah, and that is it. Okay. All right. Lots of things and stuff to discuss. The judge wants the jury to get the case tomorrow so they can start deliberating tomorrow. That's good. She did talk about extra security concerns, which is interesting to me. So David Yannetti has set up a satellite office that is 10 minutes from the courthouse because his office is, I don't know where, but it's too far away from the courthouse. And the team goes there every day to eat lunch and do whatever work they need to be done. And there were many interns, law school interns working for the defense team. Many of them graduated from law school during this trial. I don't know how many are left, but there are a few, and everyone's working like around the clock on this case. And so they go back there for lunch because there's no place for them to eat lunch in the courtroom. And so that's what they've been doing every day. And that's why they said, listen, we need more than 10 minutes to be able to get back here because the office is 10 minutes away. And she even said to them, oh yeah, tomorrow you can eat lunch at the courthouse. We'll make some accommodations for you. Maybe we'll give you a room. Maybe we'll give you a room. But she wants to be able to start right tomorrow at 9:00 with closings and then jury instructions. I think that's the way she does it, right? Closings first, jury instructions later. Refresh my recollection in this jurisdiction about who closes first. Is it, in some jurisdictions, it's prosecution, then defense, then prosecution gets a little bit of a rebuttal. But I think here it's, refresh my recollection because I'm conflating all of my trials right now. The defense closes first and the prosecution closes second. Last, so they get last licks. Yeah, the defense is first. Okay, that's what I thought. So they want to be able to, come back with more than 10 minutes notice in the event of a verdict because they all got to get back there for the verdict. Let me get rid of this banner. Let's get to all of the questions. She said she's going to consider the stronger instruction on the hoodie issue, and Lally's argument was laughable. Brennan didn't say a word today, which indicates to me that he may or may not be trying to cover his own ass. It hasn't been determined. They haven't said whether or not Lally's doing the closing. I can't imagine that he would. I mean, Brennan has tried this whole entire case. And so that just seems odd to me, but I don't think that's been confirmed, right? To the questions. The duck walked up to the lemonade stand, says she must be acquitted. This is all BS. I'm 47 in August, going back to school in the fall for allied health sciences, seriously considering getting into forensic pathology just because of this case alone. That's fantastic. You're never too old to dream a new dream. Do it. Just do it. Thank you. Lesson plans and legal drama says she isn't helping the defense. She's trying to save face. She knows she's in it. She knows she's in for it after the spectacle she made of herself throughout the trial. Disgusted. Thanks for your 20. A lot of people think she just might retire after this is all over. Maybe she's putting in getting in her papers for retirement. Catherine Smith, thanks for your 20. I'm a huge music junkie. My ex is 10 years older. Followed the Dead for years. I've seen them at least 6 times. My generation went for Widespread Panic. Yeah, I never got into Widespread Panic. I never did. I guess I was already into the Dead. And good. Your 17-year-old has good taste in music. Thank you very much. Chris, good morning. Can you do a shout out to the girls at Man's Bakery in Revere? We're free Karen Reed supporters. Shout out. I hope I'm pronouncing Man's right, M-A-N-N-E, because everything in Massachusetts it's spelled, differently. Thank you, Chris G, for your 10. Shout out to Man's Bakery. Everybody's free Karen Reed supporters. Come visit, grab some great food as we cheer Not Guilty and watch Spanky cry. # free Karen Reed. Thanks, Chris. That's from earlier this morning. If you don't know about Man's Bakery in Revere, you should go. You should go there. Chris says so, and she says it's good. I mean, and if they're free Karen Reed and they watch my channel, absolutely we support them, right? Thank you. Marilyn Price says they saw the John Stamos clip in concert. He said free Karen Reed. Yeah, apparently you guys are pointing out that John Stamos tours with the Beach Boys. Sometimes RIP Brian Wilson, who passed away yesterday. And he said free Karen Reed. That's crazy. Go John Stamos. Uncle Jesse. He was Uncle Jesse, right? In Full House. Lowiski, Hank is Dick Dastardly and Lally's Motley. He's the dog in this case. It's funny. Jennifer says no evidence of a dog except the large wounds on our victim's arms. Arm, poor sweet innocent animal blamed for owner's behavior. Yep. Pink Wildflower says, since the defense hasn't rested its case in chief on record, can they change their mind and call more witnesses like the Alberts or Higgins? No. No, I mean, they've told the judge that they're resting, and so they can't do that. They've also not asked for the missing witness charge, but they're still going to be able to argue that the Commonwealth would have called Michael Proctor if they thought, why did they hide Michael Proctor from you? Lillian, have more seen that lifeguard Bev takes her hand in front of her mouth and talk? I did not see that. I don't know where that is, and I haven't seen it. Thank you, Alessi, for president. Channel 5 was reporting live from the courthouse this morning that Dr. Okay, well, you wrote Wenchler. So are you saying Renchler or Welcher? Admitted he didn't have enough evidence. What BS? You've combined both of their names there, and so I don't know what Channel 5 is reporting, but don't believe everything you read on the internet or see on mainstream media, because we apparently have learned we can't trust them. Maybe that's why they're not calling Welcher back, because he said he didn't have enough evidence with the x-rays. I'm not really sure. Can we add Eiffel 65? I put this up before. I can't believe it's nearly over. What's next? What's next? You know, mean what's next for Karen? What's next for us on this channel? What's next? We'll see where we go from here. We'll see where we go. There are still the civil suits. The O'Keeffes are suing Karen Reed and the Waterfall and C.F. McCarthy's for wrongful death and intentional infliction of emotional distress in civil court. That will be ongoing. We'll see what happens next with any other arrests and things and stuff. We have Sandra Birchmore's case to cover. Lots of things. But it's work, you know, we're just going with the flow here. You never know what's going to happen next, and we pivot on a dime. Sidebar check. Can the defense play a clip for the jury of the Karen Reed interview in the same way the Commonwealth has? I don't know if they've asked to do that, and I don't know if they intend to do that as part of their closing, and I don't know if there's so many things discussed at sidebar that the answer is they would have to probably get consent from the other side, permission from the judge. They wouldn't be able to just get up there and do it in their closing. And so the answer is we don't know, because so much stuff is hidden. Yes, I do remember John Stamos on General Hospital. He was Blackie Parish. Thank you, Tracy Giuliano, for pointing that out. Everyone, please take the poll. Let's see how many votes are up to so far. 10,000, a little over 10,000 votes. So far, it's 83% say not guilty on all charges, 1% guilty of second-degree murder, 2% guilty of manslaughter, and 15% say that they think it's going to be a hung jury. So let's see if we can get some more votes in on that. We have still, I think, 20,000 people watching, so we're only at 50% participation. Everybody, you want a participation award? Give us a vote. Just click it in there. It's anonymous. Nobody's going to know who you are or what you voted, so don't worry about that. Busted Flesh, is Bev allowed to interrupt AJ during his closing argument? Well, she's allowed to do whatever she wants to do. You've seen that, right? Is it in poor form? Yes. Is it in poor form to object during a closing? Yes, but it can be done. And listen, if Brennan is doing the closing and he starts going off, spouting about things, facts not in evidence, stating things as fact that have not been proven, I do think wholeheartedly that the defense should object to every single thing, because he has not shown one courtesy for the defense. And I think that they should object vehemently, because we have seen how incredibly easy it is for him to get up in front of a worldwide audience, the jury, the judge, pretrial, without the jury there, and lie about things in open court. And I am beginning to think it is intentional, things that Brennan is doing. Thank you, Nana Bear. So the defense will close first and the prosecution will close last. Terry, if the defense is not happy with an instruction, can they bring up the issue during closing? The things that the judge has said they specifically cannot talk about, like third-party culprit against Brian Albert now and Colin Albert, they cannot talk about. They are allowed to talk about Higgins. And so you got to be careful, because you don't want the judge interrupting your closing. And they know what to do. They know how to do it properly. Brennan, on the other hand, I'm not so sure about. And that's why I say that they need to object as much as possible during his closing if it's warranted, which I'm pretty sure it would be. Hi, I am BB. We know AG needs to pound home reasonable doubt. You're not here to solve it, etc. But what would you say about the alleged DUI blood test? I'm concerned this has been lost. Thank you. I don't think there's any need to focus on it. because I think the only thing, one of the things that I will give a check to in the Commonwealth list of things that they may have proven is that Karen Reed was drinking and driving. Karen even admitted it during some of her interviews. And so I don't think that they should focus on that at all, because it's a non-issue. I think what they need to focus on is John O'Keefe was not hit by a car. A car did not hit John O'Keefe. That is the first thing that you need to decide. And if you decide that it's not guilty, we're done here. If there was no car accident, there are no charges. And so I don't think they should muddy it with the DUI blood test. There is no standalone DUI charge, and that is my opinion. And we still don't know if she's going to allow them an hour and a half for their closings. Did she ever decide on that? She only gave them an hour last trial. Alan Jackson argued yesterday that's not long enough. We need an hour and a half. She said, maybe I'll give you an hour and 15 minutes. I'll think about it. We've had 30 days, 30 full days of testimony. 1 hour is not enough for closing. She said 75 minutes, but did she still say, I'll think about an hour and a half? Or was she firm on the hour and 15? It's still not enough time. Still not enough time, in my opinion. So that even, you got to really narrow down. True, but the last jury was misguided and focused on alcohol. But there is no standalone DUI charge. So maybe they can spend some time on it. But I think based on Karen's own admissions in her interviews, why highlight it again? Giving that GP life the sloth style. Thank you so much. So glad I found you for season 2, how to try to figure out season 1 alone. But what you do has helped me so much. And then some. Well, I've got a full-on playlist for trial 1. If you feel like going back and watching it. Thank you so much for your 20. Lisa asked that, will they still be able to mention Brian Albert not coming out of the house? Well, yeah, it's not pointing to him as a third-party culprit. So in my opinion, they would be able to talk about that. It's not saying that he did anything wrong, but he didn't come out of the house. He's a first responder. Will they say that? I don't know. Would they be able to? I think they probably could. Thanks for gifting GP Sloth Style. Don't worry, baby. Beach Boys, RIP Brian Wilson. Thank you. Grandma Tutu for tuning in from Canada. Let's be honest. Mel, is there any oversight of this judge? Given her obvious bias, it's possible she'd be held accountable for the circus. P.S. You're a rock star. Thank you so much. There's a board of judge overseers. I don't know what they call it in Massachusetts. There is, there is. Will she be held to account for anything? Judges have wide judicial powers, discretion, and as she likes to say, I've been upheld. So this has gone up to the appellate courts, and she's been upheld. And so unless there's something egregious, I don't know if that judicial body would have anything, will do anything about her. All right, we're up to 11,624 votes. Keep voting, guys. Keep voting. Thank you very much for that. What does it mean the Commonwealth asking for only one charge to be read in jury instruction? I went over that at the beginning of the stream. If you weren't here for that unlock, just go back and rewind it. And I went over the entire charge and the things that the Commonwealth was not asking to be read about intent. And I did it at the beginning of the stream. Thanks for your super chat. Welcha gifted 10 memberships. Thank you, Welcha. You're amazing. Pineywood, she's being way too vague on her orders here. That was a huge problem last time, and she did not ultimately do what she said she would. Ask for particularity. Best gun losing detective. Don't they need all 3 prongs to prove the charge? No, it is this or that or that. So it's not this and that and that. It's this or that or that. So no, they don't need all 3 prongs. It's an alternative for second-degree murder. Judd Welcher crash test dummy. I hate lesser included charges. I do too. It did not hit him, so it doesn't matter. What is the Commonwealth's theory? Did Karen hit John? How fast was she going? What body part did her vehicle come into contact with? The sweatshirt is blown up in Hank Brennan's face. Explain it to me like I'm 5. I can't explain it to you. I can't explain it to you because I have no idea what their theory is anymore. I just don't. And so we can go back and watch Brennan's opening. and see if he proved it. Is he going to change it in his closing? Probably. Probably. If you guys want to go back and listen to his opening, we can do that after we get through some of these, some more of these comments. There was 3 parts of it, yes, but it is this or that or that. I'll pull it up for you so you can take a look at it, okay? Let's do that so we can, you can see the receipts while we talk about it. Let me just get it ready. Hold on. I have it up. We'll go back to it as soon as I address some more of these comments, okay? Okay. Do you think Lally's doing the close because the jurors hate Brennan? I don't know that he is doing the closing, CatQ. I don't know that he is. I don't know that that's been confirmed. So I'm not sure. Can the defense say something about the rock in closing? Yes. The judge has already instructed them that the rock wasn't there, and she says she doesn't want to address it again in the jury instructions that the jury will hear. So yes, they can. Remember when you went to the view? Remember when you went on your field trip to 34 Fairview and you saw that rock? Maybe they didn't see it. Maybe some people didn't see it, but the media saw it and they were all over it. One of the few things that they've been all over in this case that was actually positive, in my opinion, for the defense. And remember, the judge told you that that rock was not there on January 29th, or yeah, January 29th of 2022. Yes. Insane with the sustain says, juror no notes obviously knew the state would take their notes and destroy them. He will be the holdout, has a brain. Some people have photographic memories. They don't need to take notes. It's hard to say whether that juror is for the defense or for the prosecution, right? So I don't know. There is one juror who has not been taking notes. That juror is now sitting in seat number 1. Daniel, with the trial coming to an end soon, need to become a member and support the stream. Oh, thank you. Thank you so much. Free Read, Daniel. Big Haas, have you added the song I'm Blue Da BD? I don't know that song, but I'll check it out later. Angie's Wave says, ham sandwiches for all. Melanie, thank you and Moz for all you do. After 3 years following the case prior and through the first trial, I'm hopeful for acquittal. It's definitely inspired a new generation of STEM and law careers. Yeah, I hope so. I love to see women in STEM. Sherry Sullivan, can someone be reading jury notes left behind to see where a juror might be leaning? They're not supposed to be. Is anything possible? Of course. Is it probable? I don't know. Is it actually happening? I have no idea. They're supposed to be locked up at the end of the day. They leave the notebooks on their chairs. But yeah. God save us from the Commonwealth says, it's weird that the trial started on April Fool's Day and goes to the jury on Friday the 13th. I hope it means good luck and not bad. Yeah. Guzma Breenin, Professional Tool, says, imagine how different things would be if we had the Russ Baldwin judge for this case. Oh boy, yeah. That Mary Marlowe Summer, she was not having any of it. Even another judge in this building like Judge Halal or Judge Sisitsky. This would have been a very, very, very different case. Why mention security issues? Thanks, Keith, just Keith. Perhaps because if it's an acquittal, there could be security issues. And if it's a guilty verdict, there could be security issues. I mean, I could see it going both ways. And they may need to hire extra staff, have them on hand outside and in the courtroom and in the courthouse. So I can see that. You know how divided the public is on this case. Not that there would be riots or anything, but there could be some unrest on either side, outside. We don't know. And they need to take that into consideration. Good morning, J.R. Kuber. Can the defense object during Hank's closing? I think I just addressed that, and I think that they should, if it's warranted. Prayers up for Karen and her team. LJ, in my opinion, in this day and age, with all the division in our country, it's scary that the 12 jurors could also be divided. I pray that common sense is stronger than division. Well, we prayed for that during season 1, and it did not happen. And if you believe the jurors that came out after, I forget what the final split out was on manslaughter, and I don't know if it was ever really confirmed, but the first jury was split something like 8-4. Was it 8-4, leaning towards guilty on manslaughter? So that's the way we've seen this film before, and we didn't like the ending. We're hoping for a better ending and a different ending this time, but I don't know. Jessica, how did it get to near the judge? Yeah, I don't know. How did that, that's what I want to know. Jessica, how did that sweatshirt, the hoodie get up there? Who put it there? Who got it out of the evidence room? Was it Clerk Jim? I have questions. Darlene, what would be the follow-up steps for Hanky to answer for his misconduct? Somebody would have to report him. That's involved in this case, and they would hear it in the Board of Bar Overseers. Angelique, thanks for everything you do. Oh, thanks. Your page, my new home. Oh, thanks, Angelique Leslie. I appreciate you. Weekend at Bevy's. Oh, I love that username. Well done. Heard you're a Rangers fan. I'm on Prince Edward Island, Canada. Were you an Adam McQuaid fan? His brother was my lawyer in one of my motor vehicle accident suits. No, that's crazy. That is so crazy. I think that was before my time. But that's awesome. Ellen, why is the Commonwealth not doing a rebuttal? That your guess is as good as mine. Have they decided, number one, their case is already tanked, and what's the point of bringing Welcher and the others in? Is Hank Brennan trying to save his own ass? Is Welcher going to roll over? Or is Welcher mad? And did Welcher refuse to come back and said, dude, you kept those x-rays from me. You've already ruined my reputation. How could you ruin it anymore? Have they abandoned their no dog DNA theory? Because what evidence or what witnesses did the Commonwealth put on to say that those were not dog bites? They never called Crosby. Now they're not calling the dog DNA people. I don't know for sure. Welcher watched the other experts and knew that he couldn't counter. Could be. Sammy Grove says that. People say Hank's saving his ass. Rachel, Brian Higgins did not unalive John. O'Keefe, the Albert family would not protect him if he had. I mean, that's what I've been thinking anyway. What do you think about that? I don't really think about that much, Rachel. Something happens to John O'Keefe. Whatever happens to John O'Keefe, he was not hit by a car. That's about as far as I go with that. But a lot of people think that the Alberts and McCabe's would not protect Higgins. But if something happened like an accident on their property and they could be sued for it, would they be trying to avoid a lawsuit by trying to cover it up and making it look like he was hit by a plow? I don't know. I don't know what happened, but I know he wasn't hit by a car. Thank you, Misty Meadow, for giving me money from your swear jar. Deleted comment queen. Thank you for the days by the Kinks. Thank you. To everyone I've been spending 8 hours a day with, we have one thing in common in hating injustices of any kind. Love to all. Yes. Yes, we're going to have to, I don't know, maybe we should become the Innocence Project of YouTube and like cover cases that are wrongful persecutions and, you know, things where, and I do choose the cases that I cover very carefully. Trust me, when I started talking about this case, not a lot of lawyers on YouTube were. People were afraid of it for good reason, maybe. And I just felt so strongly about it that I decided to cover it and keep covering it. As a side note, for those of you who followed the Carly Gregg trial with me, Carly Gregg is a 14-year-old who was tried as an adult in Mississippi. She's been sentenced to life without ever having the possibility of parole. Her grandparents want to come on my channel and do an interview, and they say they have a lot of information that the public doesn't know, and they would like to share it. So if you're interested in hearing from Carly Gregg's grandparents, let me know, because I am. When all this is over, we're going to pivot to some other things. All of AJ's Nichols, too funny. The case starts on April Fool's and begins deliberations on Friday the 13th. Yep. Thanks, Chuck. Free super sticker. Karen is found not guilty. Can the civil suits for wrongful death continue? Yes, they can. Or will they be dismissed because proof she didn't kill him? Nope, they can continue because the burden of proof in a civil case is far lower. It's not beyond a reasonable doubt. It's just preponderance of the evidence. So in a civil case, it's like, imagine Lady Justice. She's back there. And her scales are like this. And if you tilt them just a little tiny bit, that's a preponderance of the evidence. Remember OJ? OJ was acquitted, but he was sued in civil court, and those cases were successful. So it can continue. Lena, did I miss them asking to see the alternate juror numbers? They haven't picked the alternates yet, Lena. That won't be done until after closings and after jury instructions, I believe. Yeah, you want to hear from Carly Gregg's grandparents. Poor family. Yeah, I know. That was a tragic case as well. Chuck, did she say if the jury will deliberate Saturday and Sunday if they don't finish tomorrow? She did not, and my gut tells me no, she will not have them come in over the weekend. She did not have them come in over the weekend last time when I think they were deadlocked on a Friday, and she let them go. They went home for the weekend. They've never deliberated. They've never come in on a weekend, and so I just don't think so, Chuck. She didn't specifically address it, but she did say she was going to ask them if they can stay until 5 or 5:30 tomorrow, which indicates to me that she thinks they may come back quickly with a verdict. And typically, statistics show that if a jury comes back quickly, it's usually an acquittal. It's much harder to get 12 people to agree on guilty than not guilty, apparently, according to the statistics. All right, I'm going to end the poll in a second. So if you guys want to get your final votes in, we're up to 12,000, almost 13,000 votes. Let's let it go another. We have 16,000 here. I think a sub shop should come up with a ham sandwich and name it the Wrenchler, and White Claw should come up with a flavor named Misty and Eddie. Oh, the Red's daughter, you're so cute. YouTube girl says, can anyone step in and stop a third, fourth, fifth trial if hung juries continue? No, Massachusetts have been known to prosecute people 3-4 times. Unless the prosecution dismisses the charges or the FBI steps in and does something. I don't know who else could stop the trial. If you're in Massachusetts and let me know. Also, if there's one juror not in agreement, can they pull in an alternate? No, they cannot. Nope. No, that's a great question, but the answer is no. And Margaret being there today gives me faith that perhaps the bingo balls will be done properly, because if you watch the Turk trial with me, you know how Margaret did it. She laid all the balls out on the table for all the attorneys to see, to show that each juror was represented, put them in the bingo drum, spun them around, and as she pulled them out, she held them up for everyone to see the numbers that she was calling, very unlike what Clerk Jim did in season 1. The heir apparent. Bev gets Judge of the Year. A decoration on from Marcy. This trial is a jewel in his crown. Her crown is off to Cape Cod to retire. I think she may put it in her retirement papers too. If you don't know, she was given an award at the Norfolk County Bar Association dinner one day, I think maybe 2 weeks ago. She was Person of the Year. I don't know if there's any footage of her speech or anything floating around, or if there was everyone had to put their phone in a basket when they came in, like Soho House. I don't know. I didn't see any. Rescue Randy going for a ride with HB. Good morning from Southern Cal. Good morning, Edmund. The Commonwealth. Edmund, you wake up so early. You are so in this. You are so dedicated. You are really full on here, getting up to start watching me at 6 a.m. in California. Does the Commonwealth get to have 2 closing arguments or 1 each? Thank you. No, they just get 1. The defense closes first. Commonwealth closes second. Bias Bev says, unfair for jurors. What? And no fairness for Karen Reid. Yeah, we've seen this. It's been a recurring theme. It's all about fair trial for the Commonwealth, which, by the way, is not a constitutional right. It's the defendant who is constitutionally given the right to a fair trial. And everything is asked backwards here. Sarah, thank you for your super sticker. Will we be able to see alternate numbers being picked? Yeah, I'm sure that the defense is going to make a big stink about it this time, based on what happened last time. Portia Milner, Bev seems mighty sure of a quick verdict. Yeah. But again, if it's quick, in my opinion, it's an acquittal. And we may have it on tomorrow. We may have a verdict tomorrow, and then happy Father's Day to Mr. Reed. Sounded like they added a DUI lesser included. No, that's not it. That is not it. But I will read the manslaughter charge to you, Cindy, to clarify any confusion. The dusty truth, Hanks to go through unproven facts agenda again. Yes, and I hope that they do absolutely object. Because the last thing the jury's going to hear before the hella long, boring jury instructions is Hank Brennan's closing. If it's Hank, Lally got up and did all the talking today, so I don't know. I don't know if he's just like, I give up, I quit. Because he's getting paid either way, remember? They both are. Kayaking Girl, is there any way Bev can choose to use her threatened sanctions regarding ARCA payments to hamstring the defense in some way to deny their motions? This was at 12:15. I'm not sure what motions you're talking about. Pretty much everything's been ruled on. And so unless there's a specific motion that you're talking about, we're pretty much at the end of the road here. Danielle, explain how and when the alternates are picked. I think I just did. The bingo drum after jury instruction. I'm not sure if she does it before jury instructions or after, but she does it after closings. I thought they just asked for lesser included for OWI. I don't know. I don't know who this person is, but please do not be directing people to other channels. It's just not cool. In addition to the all caps rule that we have for mod use only. Thank you very much. Brian Miller, I thought they just asked for lesser included for OUI. We'll go over that. The Commonwealth's proposed jury instructions and what the lesser includeds are for manslaughter, and there is not a standalone OUI charge. It would be impossible to prove because there was no testing done at the scene. Amos Lee has a song, 34 Fairview Road. I love him. He follows the case. That's cool. I haven't heard of that, but I'll take a look. M169 just sent in a couple of songs to my email. Looking forward to your thoughts when you get a chance to review them. Thank you. I do read all emails. I do not get a chance to respond to all of them, as you can imagine, but I will look for it. Thank you very much. Canoni's Baloney. Turtle Boy says that juror was first to be picked, hence seat, and is very chill in Aiden's word. Turtle Boy isn't at all concerned about him. Oh, you mean the one who's not taking notes, the no note taker? That's good. And he's been in the courtroom, so he's been able to get eyes on them, and that's good. Mrs. Micmac, thanks for tuning in from Australia. If international viewers want to donate to Karen's Defense Fund and the link doesn't work, you need to use a VPN to change your location to USA. Much love from Australia. Thank you for pointing that out for people. The link to Karen Reed's Defense Fund is in the show notes below this video. You may need to close out the chat. Off topic, but a big red flag is Jen didn't immediately go inside. I agree with you, Carrie. If I go to my sister's house and there's a body on the lawn, I am yeeting inside. Oh, yeah. Especially if that 507 call to her sister went unanswered, which she said. And yesterday, we did a 36-second phone call. You can say a hell of a lot in 36 seconds or 38 or whatever it was. We did it. We did some improv yesterday, remember? And I would too. I would run inside and make sure that my sister's family was okay, especially since Brian Albert worked with dangerous criminals. He was on the fugitive task squad force, right? The door is unlocked, right? Do you believe that, Melanie Little's middle finger? I don't. Somebody must have came down and unlocked the door so that she could run in. Misanthrope, the collective unconscious exists. Carl Young, keep the not guilty faith. Thanks for all you do. You're the best. No, you are. Amy in Arizona, does Rescue Randy prefer mustard or mayo on his ham sandwich? Don't even. Amy, no mayo. We decided yesterday. You asked that question yesterday, and I don't answer. Lena, sorry, I just meant to see the numbers, not choose them. Sorry. Yes, you can see the numbers. Yes. Yes, she will get to see them. They will get to see the numbers. Weekend at Bevy's. Wasn't that a party? Irish Rovers. Thank you. Scooter, I had a forearm strike injury a couple of days ago. The scratches are horizontal, not vertical. It also bruised and excruciating. You were hit by a car on your forearm a couple of days ago. That is something that was also pointed out with Dr. Rentschler, right? Proctor's honorable text. You've made this case tolerable to watch. Thank you. I don't think I could have enjoyed it without you. After Karen's found not guilty, what is your next case? Whatever you guys want to do, whatever you want to pay attention to. Let's find some people out there that are being wrongfully persecuted and highlight their cases. That's my idea. I don't know what happened with Koberger's trial. Is it going to happen in August? Has it been pushed? I covered that in the very beginning when it first happened with Judy Ron and Ed Wallace on their channel before I even had a YouTube channel. And I haven't been able to cover the motions or anything because I've been single thread on Karen Reed for a long time. Although we have handled some other cases and trials as this was going on, obviously. But so I don't even know if Koberger is going to happen in August. But our next case, Proctor's honorable. Let's call it our next case because I'm here for you guys. Whatever you guys want to do, I'll do. Amy in Arizona, after hitting Rescue Randy at 24 miles an hour, Aperture saw the damage to the Lexus, plus significant injuries in ARCA's report. And not a coincidence, they pivoted to 8 miles an hour since the taillight had minimal damage at 10 miles an hour. Yeah. You're thinking, and I know you're watching this for the first time, and I like it. Dana, baby. Bev talking about security because she already knows it will be a guilty verdict. I trust no one that this jury isn't fixed. Listen, they're going to need security either way, whether it's guilty or not guilty. Right? And so I don't know. I don't think so. I don't think so, but people might think that. You might think that. Thank you, big cup of tea for your super sticker. Cat artist, why does the Commonwealth act as if Karen Read is such a threat to our society? Come on now, really? Free Karen Read. Cindy, Yannetti read during the verdict slip discussion. About a standalone OUI charge? We're going to look at the manslaughter charge, okay? Let's do that. Give me a second, though, Cindy. Just give me 1 second. Bruce West, my phone uses facial ID to get a lot of butt dials. You have to be butt ugly. Well done, Bruce. Well done. That was funny. Odin's martyr. If you're not supposed to start deliberation with a straw poll, how do the jurors get started? Well, she can tell them not to. That doesn't mean they don't. And that doesn't mean they can't. She does. And she said that last time too. I suggest that you don't go in there and do a straw poll. And that's what a straw poll is. Everyone go around the table and tell me what you're thinking. Guilty, not guilty. And then if they all say not guilty, maybe they eat their lunch and then come out and just announce it after. Or maybe they say, we want to go home today and come back and announce it Monday because they want to prepare and look good for the media. That happened didn't that happen in the Murdoch trial? Where everyone came in all dressed up for verdict day because they all wanted to get out there and talk to the media. So that happens too. Scooter, I pulled a Judson Welcher, literally walked into something and disproved the theory. He did it on purpose? Dude. Or sis, what is up with that? All right, let's look at the proposed jury instructions for the Commonwealth so that we can look at the manslaughter charge. Because earlier this morning we went over the murder 2 charge. So give me a second. Here's manslaughter while operating a motor vehicle under the influence of liquor. I think we looked at this the other day, but since we're all here, 15,000 strong, let's do it again. This is the charge. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Well, I think we can check that box off, right? People saw her driving in the driver's seat. We have witnesses that saw her in the driver's seat out the side 34 Fairview. I think that we can check off that box. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right of access. Well, there was a witness who came in and said that Fairview Road is a public way. It's not a private road. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. So they don't only have to prove that it was 0.08 or greater. That's where the extrapolation and the calculations come in and the blood draw. They can just prove that she was under the influence of intoxicating liquor. And that's where her interview comes in, where she said on camera during one of her interviews, something about, I may have had 9 drinks. In another interview, she said, I think I had 4 drinks. She may have said I didn't drink them all. But she did say vodka and she did say drinks. So for purposes of this discussion, let's assume that they can all agree that she had some drinks before she got in the car and drove it. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that a substantial harm will result to another. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Okay. And that is where they may say, no, she may have been driving. She may have had some drinks. She may have been over the legal limit even. But the motor vehicle did not cause John O'Keefe's death because he was not hit by a car. Picking it up. Mass Gov, hold on. Mass General Instruction 2.420. Okay, thank you, you lady in the back. Let me get that up. Excellent. I have it up. We'll take a look at that. Thank you to you, lady in the back. And I can't highlight your comment right now because I'm on a different screen, but we will take a look at that. Thank you. You get full faith and credit for that suggestion. To prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the well-known things that drivers do as they travel on a street or highway. Let me just fast forward a little bit. So I think beyond a reasonable doubt, we know that she was operating the vehicle. We know the second element, that she operated it on a public way. And it says, footnote 2 here says, the Commonwealth requests a special verdict slip that contains both theories, operating a motor vehicle under the influence of intoxicating liquor and or operating a motor vehicle with a blood alcohol content of 0.08 or greater. So they're requesting both theories here. So both theories, meaning both theories with regard to the manslaughter. It's not both theories in that in that it's just DUI. Okay? Both theories with regard to the manslaughter. Okay? And they are a little bit confusing for people who are not lawyers and don't read these things every day. And so, and her instructions last year were confusing for many lawyers who have done this for decades. So here it is. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was 0.08 or greater. I will now instruct you on both theories. So they want both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. That is why I think they're asking for this, because Karina Kolakithis said, she seemed fine to me. A person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that their ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this first theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed any alcohol. So that's a may. You may consider. So they can just determine based upon the testimony, Karen's statements, whether or not she was under the influence of alcohol without considering the blood test. See, so there's two different ways. It's this, and it says you may consider the blood test. However, no matter what the reading is, the blood test is not sufficient by itself to prove that the defendant was under the influence of alcohol. Under the second theory, the Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pretest procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test or the test results. Moving on to the fourth element. The fourth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. Well, don't we have testimony in season 2 from Ryan Nagel and also Heather Maxson that she seemed to be driving fine? So a lot of jurors may think about that. Hang on for 1 second. They're not deliberating today because there hasn't been closings yet. Closings are happening tomorrow, G. Tell me you just got here without telling me you just got here. It is not enough for the Commonwealth to prove that the defendant acted negligently, that is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger of death or serious injury to others, but chose nevertheless to run the risk and go ahead. Some of the jurors may say also, well, John was a cop. Why would he let her drive if she was hammered, right? The defendant must have intended her acts in the sense that they were not accidental, but it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in that category of cases where the public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. And then it goes on to decide to talk about whether, in determining whether the defendant drove recklessly, what you need to consider. But however, but again, I mean, if there was no car accident, none of this matters. Going to the fifth element. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant's act is the cause of death, where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all 5 elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. So they have to prove all 5. Here's the charge on leaving the scene of an accident resulting in death, and that is the 3rd count. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. So all 6. First, that the defendant operated a motor vehicle. I think we can check that off. Second, she operated on a public way. I think we can check that off. Third, that the defendant knowingly collided with John O'Keefe. So they would have to say that she hit him and she knew she hit him. Fourth, that the collision caused injury to John O'Keefe, resulting in his death. Fifth, that after causing such injury, the defendant failed to stop and provide the name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Well, remember, in season 1, The jury came back afterward, or many of the jurors came back and said, we acquitted her of this charge, which leads me to believe that they all agreed on number 3 here. Oops. That Karen did not know that she hit him. So they said not guilty on this, and then they were hung on the manslaughter. Well, if you believe the jurors that came out, because not all of them did. Now let's go back to the murder in the second degree. And this is what they wanted to remove, but the judge has now said that she doesn't know if she's going to remove these. So these are the prongs. And I'm just going to say again, because we went over this earlier, is see how there's or in the statute or in the charge? Second element is that the defendant intended to kill John O'Keefe or intended to cause grievous bodily injury or harm to John O'Keefe or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. So for second degree murder, you don't have to find this, this, and this. It is this or this or this. Commonwealth has said, we don't even want you to charge that she intended to kill him or that she intended to cause him grievous bodily injury or harm. We just wanted to charge this. She intended to do an act which she knew or should have known would have caused death or could have caused death. The defense says, we don't really care. Because again, they thought they have proven beyond a reasonable doubt. They don't have to prove anything, but they think the Commonwealth failed to meet its burden. That John O'Keefe was even hit by a car. And the judge said, despite the fact that the Commonwealth wanted to take A, B, and B out, that she was going to think about it, right? Okay. So there's that. Siobhan says, it makes me so sad they're so intent on framing Karen Reed that they are losing sight of justice for Officer John O'Keefe. I agree. It's not about justice in my mind. It's about conviction. They want a conviction. If they were searching for the truth, they never would have fought having Karen bring in all of her experts, right? Corrupt CW, how do they pick the jury foreperson? Oh, good. Thanks for asking, because we have we have some instructions here. This is the Massachusetts, I guess it's a jury instruction. Hold on. Well, this is the jury instruction on it, but it doesn't say. All right, well, let's pull this up anyway and take a look at it because we like receipts here. It's not really the guidelines for the judge. It is the jury instruction. So let's take a look. All right, I'm going to end the poll. If you want to get your votes in, do it now. What will the jury do? Not guilty on all charges. Right now we have 14,000 votes. 83% say not guilty on all charges. 1% guilty of second degree. 2% guilty of manslaughter. 14% say they think it's going to be a hung jury. All right, ready, set. Last call. Last call for alcohol. Last call. Closing time. You don't have to go home, but you can't stay here. All right, ready? Up. And I'm going to end it now with 14,725 votes. 83% say not guilty on all charges. Let me just take a quick shot of this. Oops. Because it disappears for some reason in the replay, right? 83% says not guilty on, say not guilty on all charges. 14% hung jury or won't agree, mistrial. 1% guilty of manslaughter, and 0% for second-degree murder. And we had over 14,000 votes. That's a good sampling. That's a good sampling. Let's take a look. Wait, hold on a second. Oops. Where'd it go? Where did it go? It's easier to download it. Okay. 2 minutes to talk amongst yourselves for a second. This is interesting because this was revised in July of 2024. What happened in July of 2024, my friends? The mistrial on Karen Reed was July 1st of 2024. So it's interesting to me that this jury instruction was revised in July of 2024, likely after her trial. Thank you, Corrupt CW, for asking. This is jury instruction 2.420 to 420. That's interesting too. Revised in July of 2024. Look, it says it right here. Up in the upper right-hand corner. Reducing the jury, selecting the foreperson, and sending out the jury. And this is what the judge is supposed to say. When we impanel a jury at the beginning of a trial, we never know whether some personal emergency will arise during the course of the trial, which will require one or more of the jurors to be excused from further jury duty. To avoid having to start the trial over again, if that should occur, we impanel 7 jurors, even though the case will eventually be decided by only 6 of you. Well, this must be the civil instruction. And so whoever pointed me in the direction of this instruction, it may be the civil one, but let's just maybe assume that it's the same for criminal court. I don't know if I ever like to assume anything because it's 18 and now it's got to be reduced to 12. Time has now come to reduce your number to that 6. The clerk will draw one of your names at random. That juror will be designated as an alternate juror, or in this case, 6 alternates, and will not take part in deliberations unless it's necessary to provide a substitute for one of the other jurors. If fate makes you an alternate juror, please don't take it personally. Your presence up to this point and your continuing availability, if you should be needed, is itself an important contribution to the administration of justice, right? So the alternates, even though they're selected as alternates, have to be on standby just in case during deliberations, one of the deliberating jurors has to drop out or gets kicked out for whatever reason, and then an alternate would be chosen to come in, and they would have to start the deliberations all over again. The court officer will make you as comfortable as possible while the jury deliberates, and then says the clerk will now reduce the jury to 12 jurors. And then the clerk should place the names of all the jurors in the drum, draw the names of the 1 or 2 alternates, or in this case 6, and address them as follows. Clerk, juror number blank and seat number blank, you are hereby designated as an alternate juror, and then repeat the process for 5 more. You'll be kept separate and apart in the attendance of the court officer unless you are later drawn to replace a sitting juror. And then it says, juror number blank, I appoint you to be the foreperson of this jury. As the jury foreperson, you will have 3 jobs. So in this jury instruction that we're reading here, first they draw the alternates and then the judge appoints the foreperson. That's not what happened last time. Last time, the judge appointed number one as the foreperson, and then they picked the alternates, I think. So what this says is that they're supposed to pick the alternates first, and then the judge appoints the foreperson, which is weird. Because in New York, whoever is seated in seat number one is always the foreperson. In other jurisdictions, the jury goes back and selects their own foreperson. In Massachusetts, the judge picks the foreperson. As the jury foreperson, you will have three jobs. First, you will be the liaison or link between the jury and the court. As you deliberate, if you have any questions about the law, you should write it down on a piece of paper and hand it to the court officer. The court officer cannot answer any of your questions about the case. I will either send back an answer in writing or have you come back into the courtroom for further instructions. Second, as foreperson, it's your job to encourage discussion among your fellow jurors. To that end, the foreperson should see that all jurors have a chance to participate in the discussion and that all points of view are considered. As the foreperson, however, you do not have a greater voice or vote than any of your fellow jurors. Finally, as foreperson, you have an administrative role. Yeah, she did pick the foreperson first, right? After all six jurors have agreed upon a verdict, fill in the verdict slip, date it and sign it at the bottom, place it in an envelope, and then let the court officers know you have reached a verdict. You will then be brought back into the courtroom where you will announce the verdict in open court in response to the questions from the clerk. The deliberating jurors will then be asked if they agree with that verdict. If several offenses are charged, there is one verdict slip for each charge, and then it says explain verdict slips as necessary. For all of the jurors, I emphasize that you may not use cellular telephones or any other personal wireless devices during deliberations. Incoming or outgoing calls or other electronic communications may disrupt the deliberative process or allow for the receipt of improper extraneous information. I think some criminal trials, Nick, if they're not felonies, they use 6 jurors in Massachusetts. You guys can correct me if I'm wrong, but since this is a felony trial, it's 12 jurors. But I think perhaps in non-felony cases, they only use 6 jurors, and that's why it reads that way. But it would be obviously amended to say 12. You are not to conduct any outside research or investigation by means of the internet or otherwise about the law or facts of this case. The clerk will now swear the court officers who will escort you to your deliberations. Clerk swears court officers. You solemnly swear or affirm that you will take charge of this jury and keep them together in some convenient place that they have agreed, or keep them together in some convenient place until they have agreed, that you will not speak to them nor suffer anyone else to speak to them except by order of court or to ask them if they have agreed. So help you God. Judge, members of the jury, you may now retire to consider your verdicts. It says here notes. Oh, the notes. This is where you always find the good stuff in the notes. Reduction of jury and designation of alternate jurors. Alternate jurors are not identified until immediately prior to jury deliberations, pursuant to the procedure explained in this general law. All right, so that answers one question. 2, time of selection of foreperson. And remember, this was amended in July of 2024. Although General Law 234A states after a jury has been impaneled and sworn, the court shall appoint a foreperson, common practice in the district court is to select a foreperson at the close of the instructions just prior to deliberations. The manner in which the foreperson is chosen lies in the discretion of the judge. So it's the discretion of the judge. And this is not district court. We're in superior court. It says the court shall appoint a foreperson. She's got wide berth for discretion. Alternate jurors are not permitted in the deliberation room. And there's some more instructions here, but I think that answers the questions that you guys had about the how the alternates are chosen and how the foreperson is chosen. Talk amongst yourselves for a second. James, thanks for your Venmo. Says, shout out to my super fan attorney wife, Carlina. Carlina, shout out from your husband, James. Thanks, James, for your Venmo. Lynn says, free Karen Reed. Thanks, Lynn, for your Venmo. Kara, want to wash that man right out of my hair. I was talking about that yesterday. I said it's from South Pacific. Yep. Thanks, Kara. Catherine, thank you for your very generous Venmo. Says, it's been great. When Karen Reed is acquitted, will she immediately file a wrongful prosecution case against the Commonwealth? Don't break my heart by telling me it's not allowed. She may have some very, very good civil rights violations lawsuits that could be filed after. I don't know if they would be immediately filed, but I think it's a good bet that when she's acquitted, such as cases like that will be filed, Catherine. Have no fear. Betty, thank you for another very generous Venmo. Thank you for a great job. Well done. Thank you. Thank you, Betty, for watching. Leanne, ain't nothing but a G thing by Dr. Dre for the playlist. Lori, what will we do with our time after Karen Reed is freed? What a great problem to have. Thanks for all your tenacity and courage. Coverage. Thank you, Lori. Cheryl says, Mel, I was outside of court yesterday. All the phones and the TV that was set up were tuned into you. Oh, that's awesome. Cheryl, I hope you had an amazing time outside with the supporters. It's really, I was fortunate enough to be able to go last year and sit in court for a day and also spend time with all the supporters outside the courtroom. And it was amazing. I mean, the love that is out there is really incredible. Lots of people who don't know each other who all came together for a common goal because they believe in justice and because they believe with all of their hearts, that Karen Reed is innocent. John O'Keefe was not hit by a car. The car didn't hit John O'Keefe. And there was really nothing like it. I mean, it was a very special thing. So thank you for going yesterday, Cheryl. And thanks to all the boots on the ground out there watching me. I love you guys. You know I do. Maura says, thanks for your coverage and commitment to free Karen Reed. Thank you. Lisa, Bev needs to see the truth, not guilty. You know, even when she's found not guilty, because I have no doubt that she will never be convicted on these charges. Do you think that the people screaming from the other side of the fence are ever going to believe that she's really not guilty? Or are they going to find something else to squeal about and go after everybody else about? I don't know. Thank you to someone anonymous who bought me a matcha latte and says, to help with today after your fun. Oh, very Raven. Thank you. Yeah, after my fun last night. I know it was such a great night. My date with Dave Matthews. What a night that was. So much fun and stuff. Buy the tickets, do the things, folks. Do it. Because you never know when your favorite band's not going to be around anymore. Just do it. Just do it. Peppermint, the most shocking moment. No rebuttal witnesses. I almost fell off my chair. Crazy, right? Irish Mima says, my preemie was born on Friday the 13th. She was a fighter, still is. Was home a month before they predicted. Oh, that's amazing. That's amazing. Have you gone through the new court papers yet? Hi, Kelly. No, they were never scanned. So we did the best we could with what we had, and we heard arguments on them. That was from earlier. Sorry. Jeff says, as I have watched the second trial, and I've noticed that the Commonwealth is acting like the defense and the defense is acting like the Commonwealth. Could that just be an artifact that Hank is a defense lawyer? No, it seemed that way during the first trial too. So during the first trial, it felt like Adam Lally tried the whole first case by himself. And it seemed like he had the ball during the entire presentation of his case, but he was running defense the whole time. He called every single witness that was inside 34 Fairview that night, every single first responder, every single person who had anything to do with this case. It went on forever. I forget how many witnesses did Lally call in the first persecution. He threw a whole bunch of spaghetti at the wall, and his entire case in chief was about defending the McCabe's and the Alberts. It was wild. And it was evident even more so, I think, during the first trial, if you did not watch it. So I'm picking up what you're laying down, but just imagine that, but 10 times more so in the first trial. Do you guys agree with me on that? Did you get your 100K plaque? I did. I got it in the mail. It is still sealed. We're going to do an unboxing of it, and we're going to do it at a special time. Not today. Thank you, Kay, for asking and for being one of the 100,000 that have chosen to hit the subscribe button below because it's free. Within 2 years of me first putting out my first live video, which was all about the Kevin Costner divorce, and you guys have been watching ever since, and I love you. Hannah says, I'm convinced there was no rebuttal case because Hank's x-ray shenanigans would be exposed. He removed x-rays from the evidence he shared with Welcher. Yeah. Is it a cover his own ass thing? True Crime Junkie says, I love watching your channel. Please, what was the name of the body language channel on YouTube you talked about 2 days ago? It's not really body language. Well, it kind of is. It's called Truth Revealed. The creator's name is Sergio Denaro, and he's an amazing, I'm sorry, I don't know exactly what his credentials are. I want to say he was an interrogator for the CIA. I may be off a little bit on that, but his entire life's work has been reading people and interrogating people and knowing when they're telling the truth and not telling the truth. So check it out. Truth Revealed on YouTube. And he's done a lot of work on this case and the witnesses in this case. Breenan's Big Binders, aka Tammy Tebow. So the trial started April Fool's, should be acquitted on the 13th. Will be free for Independence Day is my wish. Oh, that's amazing. That is amazing how you put that together, Tammy. Heather says he sometimes tours the we're going back to John Stamos now, right? And then somebody said it is true about John Stamos. John Stamos giving Karen Reed a shout out. If it's true, we need to add Jesse's girl to the playlist for Uncle Jesse. Oh, that's great. Over under on jury deliberations, length of time. We could do that poll tomorrow. John, what do you guys think? Do you guys think it's going to be a quick not guilty and we'll have that by tomorrow afternoon? Because judge wants them to stay until 5:30, which is so out of character for her. Or do you think they're not going to be able to decide tomorrow and they're going to come back Monday? Last time, how many days were they out last time? 4 days? I don't know why 4 days stands out in my head. You think they'll be out for 2, but last season, this is my real eye color. Yes, it is not. They're not color contacts. They change depending on what color I'm wearing. But yeah, this is my real eye color. It is. I don't have a filter. I don't have it just is. There's a ring light in front of me that you can probably see in my reflection, but nothing done here to change my eye color. A Season Life with Allison DeLong. Is it possible they're waiting to find out about the missing witness motion before they rest so they can call those witnesses? No, I don't think they were ever going to call them. I think they're just going to argue in their closing about and point out that the Commonwealth didn't call them. And why do you think that is? Kind of thing, right? Aunt BB, thank you. I think, we talked about this earlier, that they can object during his closing. Mike B from the 413 says, I worked in the ER over the weekend. A person who had only recently heard of the case saw my bracelets. She asked me why I believe in Free Karen Reed so much. I said, part of it is Sandra Birchmore. I encouraged her to research it. Jaw drops. Yep. John Diddy, I think a wrongful death suit should be filed when she has been found not guilty. Against who? Well, a wrongful death has been filed against Karen and the Waterfall and CF McCarthy's. So I don't know what you mean by that. That John's family should file a wrongful death suit against someone else. No matter what happens with this verdict, I think that they believe that she is guilty and they will go after her. And they will try and get whatever money from her that they can, and from her insurance and from the Waterfall and CF McCarthy's. So it's already been filed. But I don't know. She has no standing to file anything on behalf of John O'Keefe, so I'm not really sure what you're getting out there, but thank you for your super chat. Tracy said, yeah, John Stamos sang with the Beach Boys on Full House and still sings with them sometimes. There was definitely a clip. That's so cool. And then Chloe Alves Revenge says, John Stamos said it during a performance. There's a video. Aiden played it last night. Very cool. Go to his channel and check it out. Champagne ready to pop. Chicago is ready, says Corrupt Commonwealth. Free Karen Reed t-shirt wearing today. Did you see the Brennan Pee Wee Herman pic? Uncanny resemblance. Well, check out my thumbnails from a couple of days ago. I had it on there twice, I think, if that's the same picture that you're talking about. Thank you so much. Christy Betterow had a great theory that Brennan abandoned rebuttal out of self-preservation from prosecutorial misconduct regarding x-rays and dog DNA. Yeah, we talked about that earlier. I think your super chat was earlier and we our messages crossed. Do you think Hank actually believes in his case? We went over this as well. Thank you, Shannon. This morning on Good Morning America, Dan Abrams predicted a hung jury or a conviction in this case. You cannot make this up. Really, Inverted Stinker? Really? Did Dan Abrams not watch this trial at all? That's why I don't watch mainstream media, and I know many of you don't. Thank you, Welcha, for your very generous $50 super chat. The song Stand is so for Karen. Every time you get up and get back in the race, one more small part of you starts to fall into place. I'll put it on there. Thank you, Welcha. And thank you for your super generous 50. Proctor's dishonorable discharge says, looking forward to departing the land of the lost for good. Chaka has more to discover after he hears not guilty. Thank you, thank you, thank you. The truth shall set her free. The Commonwealth has not met their burden of proof beyond a reasonable doubt on any of the charges. Not guilty, not guilty, not guilty. Big cup of tea. I can't believe Bev is keeping till 5 p.m. tomorrow. She said 5 or 5:30 even. There's an annual Flag Day parade in Dedham tomorrow night. Oh. Isn't Flag Day on the 14th? Tomorrow's the 13th. That's okay. Yeah, maybe that's what she means about security then. Maybe that's what she meant. Randy's lowrider said, that's great. I think Hank has some BS up his sleeve for closing. I wouldn't doubt it. Lisa, we all need to say a prayer for Karen Reed. Absolutely. Everyone, say a prayer for Karen Reed. Lesser included, not manslaughter, says Cindy from Virginia. I didn't see any of those in the proposed jury instructions. So I guess when the verdict slips come out, we'll have to go over that at greater length, Cindy. Thank you. Honeybee, any chance that Brennan's silence and Jim's absence is connected to the hoodie being in the courtroom without the defense knowing? Could be. Who knows? Could it be? Yes, it could. Something's coming. Something's good. That's from West Side Story. If the car didn't hit, you must have quit, says Welcha. Not an OJ fan at all. Wise gal, this whole case has hung on Jen's. I hit him, yet she admitted she was drinking and groggy from taking her meds for her MS when Karen got to her house. Yes. Dan Abrams was immediately blasted on Threads. We took the poll. And when I read the results earlier. Rivera and Incarnation case videos on my channel, Blues Movers. Thank you very much. I don't know what that means, but you want me to take a look at that case? All right, I will. Thank you for suggesting it. Another wrongfully persecuted person or persons? Rivera Encarnacion case. All right, thank you, Blues Movers. I will look into that. Randy's suspended gravity. Hank is watching the Turtle Boy hearing on his computer. Does that hearing happen? Is it coming back at 2 o'clock? What's happening? Is it only on Zoom with no video? What's happening? Somebody brief me, because I've been with you, but I have no idea what's going on with Aiden's case, except is it going on day 3 today? And is it only on Zoom with no video? And yesterday, somebody who was in the Zoom room was playing my feed so loudly and it was coming through the Zoom feed. And also Andrea Burkhart's feed was coming through the Zoom feed at the Aiden Carney trial. And Glare was texting me like, you gotta mute yourself in the Zoom room. And I'm like, I'm not in the Zoom room. What are you talking about? I was so confused. And somebody else had me playing and it was going through there. It's hard to hear. That's too bad. But you know what? If Canton Community TV, and they are amazing, by the way, doing the Lord's work, is videotaping it, they may release it later on. And if they do, we will testify today, al dente. Oh man. So does anybody know if Canton Community TV is in the room and it's on video back at 2? Has video and sound, but the sound isn't good. I'd like to do it in its entirety. All right, so everyone should go to Young Jerks and watch it at 2. All right. Law and Crime Feed 10120. Cindy's not giving up on this. Cindy's got no quit. So you know what, Cindy? Just for you, Dollface. We're going to look at this. Hang on. Law and Crime Feed from today. Let us take a look. And you say 10120? Look at you. Yeah, you're doing the Lord's work for me. Thank you. And I get that from Bethany Frankel because I love Bethany Frankel. I think she's hilarious. Do you guys watch? Do you follow Bethany Frankel on like Instagram and YouTube and wherever else she is? Because she's really funny. She's always doing the Lord's work, testing chicken salad, cleaning out her closet, telling men who are married that if you don't wear a ring, you should get a tattoo on your head. That's married. It's false advertising. It's hilarious. 120. $101.20. I'm sorry, $101.20. Do 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 do. All right, I took it back a little before that. So let's take a look and see what Cindy's asking. Cindy's getting it done. She ain't got no quit. I love that about you guys. All right, hang on. I'm gonna have to turn this up really loud in my own earbuds. So let's let it play. Let me see if we can get the closed captions to work. Can't rely on them though because they're never accurate or rarely accurate. Okay, here we go.
Next charge instruction is multiple options.
I want to get back to the beginning of it. Is
Both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser includeds and the number of elements that are different for each lesser included. And we were uncomfortable with, there being one option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
the analysis is over. If it's a not guilty verdict, they go into the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the lessest, or the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty. We've also changed a little bit of the wording.
okay, that lesser included was not in the first trial. The least charge is
Of the lesser included offenses until they finally reach the final verdict, which the lessest, or the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty. We've also changed
operating under the influence where it's guilty or not guilty. It's interesting, Cindy. I don't, first of all, it didn't happen in season 1. I don't know why the defense would agree to have that as a lesser included. I don't know that they have the choice, but I kind of want to take it back to where this kind of first began. Hold on.
I don't think there was an instruction at that point.
All right. I think I have to add that here. So, all right.
Right. So she could get guilty for operating under the
And I will
influence and
look
not
at it
guilty
and
for everything
decide
else.
whether I need to add it specifically.
Yes.
It might be covered enough.
I see
Might
what
be
you're
covered
saying.
enough when I give the electronic communications instruction. So,
And I don't know why the defense would agree to that, because that's getting her guilty drunk driving charge, and that they never charged her with that. Hold on.
We would object to the part of that act being linked to the beginning of this text message.
all right, I'm going to take a look at that, Mr. Lessie. All right. Consciousness of guilt.
You're on call.
Okay. All right.
He said they were withdrawing consciousness of guilt, but then at the end, I guess Brendan was like, no, we're not withdrawing that because of her statements and everything else. All right, let me see.
Difference is, and what I gave last year from the model homicide instruction on second-degree murder, and where you're saying I should not.
Okay, we covered this at length, so let's just move up to this a little bit. Where they start talking about the verdict slips. Last year, we got a hold of the verdict slips, so we were able to talk about them while we were looking at them, Cindy, so I don't like this. Hold on. She wants case law on why she shouldn't charge the first two prongs of second-degree murder.
Lesser included offenses.
There we
All
go.
right. So, lesser included offenses. Did you want an OUI instruction? You were.
We're asking for that.
Okay.
They're
All
asking for
right.
that. The defense is asking for an OUI instruction. Cindy, catching the
Right,
deeds.
I think that's it, aside from Mr. Alessi's motion regarding the exhibit. Right? Is there anything else that we're missing?
Just a couple of other issues. One is with regard to the Proctor text messages, we have a redacted version now, which we'd like to see each list.
Yeah, here we go.
Laughlin, one of you has to take a look at it.
And then will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
An hour and 15 minutes.
All right.
And I think I did mention that we had a proposed verdict slip for count two, Your Honor, but I didn't.
You did not.
Okay, we do have one, we've given a copy to the Commonwealth. Can I hand a
Okay.
proposed copy to the court?
Sure. Is it the same as last year's, but now with a?
It's different.
Right. You're right. Cindy, you caught this. I must have not been paying attention. Thank you. So count two, the proposed verdict
All
slip.
right.
So you'll have a chance to digest that.
Oh, I digested it, Mr. Alessi. Go ahead, I'll hear you.
I'm actually an egg.
Yanetti, jeez, I'm sorry.
So, Your Honor, you'll recall we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser includeds and the number of elements that are different for each lesser included. And we were uncomfortable with, there being one option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
the analysis is over. If it's a not guilty verdict, they go into the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the lessest, or the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty.
Yeah.
We've also changed.
Yeah, you're right. You guys are right. Some people may want to find her guilty of something. And this gives them the option to find her guilty of just drunk driving. Interesting. Yeah. JJ says, imagine an OUI 3 years after the fact with zero evidence of her being over the legal limit. Would be better than murder, but unreal if it happens. Yeah. But again, it gives them a way to compromise on finding her guilty of something if there's some people that just want her guilty of something. This is a twist. And Cindy from Virginia is the one who brought it to my attention, and I'm glad you did. And we just went and watched it again. People say OUI can result in prison time. But they would have to prove that she's above the legal limit. We'll see what they argue. It's going to be interesting to see what they argue. Yeah, it's going to be difficult. They didn't do a test at the scene. Nobody collared her at the scene. I mean, exactly. Thank you, kindergarten cop, for saying this again. For those saying everyone drove, the problem is Karen was the one arrested, not everyone else. That's why you don't do interviews. They didn't do anything. They did nothing. Way to go, Cindy. No prison for the first OUI in Massachusetts? Is that true? I don't know. The defense has asked for it. They are asking for it this time. Thank you. Stronger Together standout at Norfolk County DA's office in Canton at 2 p.m. today. If anybody wants to go, says Resistant to Silence. Camille, love to know what Hank Brennan is thinking right now. He had so many objections now, typing furiously and quiet as a mouse. Didn't Larry Bird, the goat, once shout mouse on the floor or something like that? Kat says time drifting and solo cupcakes profile picture. You. Oh, I love that. I love that. I can't see it, but I'll enlarge it later. Oh, it's adorable. Oh, it's like dancing bears with cupcakes on their heads. That is amazing. I love it. I love that, Kat. Kat, can you email me like a PNG of that? I'll make a t-shirt with your permission, of course. I'll give you credit for the design. That's amazing. I love it. But the dancing bears are copyrighted, so I don't know. I don't know how that would work, but it's amazing. Well done. Kibble Wibble, can you imagine what would have happened to Karen if she decided to be stubborn and go to the house to demand John just come home and saw everything? Yeah. Or what might, yeah. That's insane. Weekend at Bevy's. Thanks for tuning in from Canada. God forbid Karen does get locked up. Can you only imagine the amount of intel that would be voluntarily given to her by others and what she would observe by staff? I can't even imagine it. Laura, thank you so much. Free super sticker. Madeline Wags, I'm so behind. Do you know why Hank didn't speak today? Do you think he knows he's in trouble, or maybe he was scolded by Meatball? One or both, or he was just trying to prepare his closing and made Lally do the arguments and prepare this for today? Because Lally has been all but silent for this entire. He did actually examine a couple of witnesses, right? Could be any or all of the above. Bravo to Travel's relevance. Are Boston PD officers required to carry their badge and off and gun? You mean badge and gun off duty with them? At the least, wouldn't he have had his badge? Where did it go? I don't know. I don't know the answer to that. If they're required to carry their badge and gun, I don't know. Where did it go? I don't know. We didn't hear anything much about the wallet or any of the personal effects, and so I don't know. Any law enforcement in the chat? Zoe B says, pop quiz. How many witnesses did Ms. Little, not me, the other Ms. Little, no relation, examine during trial 2? I thought it was only 1. Or maybe 0, and maybe she just got up and argued some things, but I think it was 1. I think it was 1. That's my guess, Zoe. You guys can guess in the chat. Lightning Dave says, first offense OUI, fine of 500 to 5,000 or 2.5 years in prison. And would we trust this judge to not imprison her? I like that. Ray Dean, good morning. Always a treat to spend the day with you too. I was rolled over by my 4Runner. I had bruises head to toe with gravel embedded throughout my clothes. He was not hit by a car. Thank you, Ray Dean. One of my Boulder girls. Kiss the Cactus, not guilty for Karen, and then justice for John. The Wander, Leaf Garrett. Thanks, Welcha. Sandra, when the shirt was objected to, the judge said, oh, I saw the shirt next to the witness stand, but I assume both sides agreed on it. She couldn't have possibly seen it. She comes in on the other side of the courtroom. I don't know what she can see from her bench, if she can see over and saw it there. I don't know. But that's a good point, Sandra. Thank you. Are we all in on the same joke? I think we're all in on the same joke. Mrs. Bouquet, thank you for watching. Be super chat. Lally proved it snowed. He did, Bruce West. He proved that during the first trial. Mama Shea, I was born on Friday the 13th, and it's always been a lucky day, so I'm feeling good about tomorrow for Karen Reed. Oh, Mama Shea. So I'll get a good night's sleep tonight. Hey, girl with the sunglasses. My mom and I were at the courthouse today. That's amazing. Oh, I can't. Are you going to talk about it later? Are you going to go live on YouTube or anything or on TikTok and talk about? I haven't been on TikTok in days, so I have no idea what's going on over there, and I don't have any of my notifications set. So I don't know what's going on over there, but I know you're on fire on TikTok and YouTube too. So go follow Girl with Sunglasses. She's awesome. Lenita said, "Thank you for making sense to all of us." I try. Amy, can't wait for the verdict of not guilty and get back to work before I get fired. Love your vibes and thank you. Sandra Beatles fan says, I'm in a town with population of 58 and spoke to a woman who has followed the trial and said Karen is innocent. Small town America is following good. 58, population of 58. And you've been here for 14 months. I don't want to dox you at all, but I would love to know what state you live in with a population of 58. And is there room and should... Oh, Coburger's happening. It starts August 11th and goes till November 7th. I think maybe we need to cover that. So we can have a little bit of a summer before we get right back to trial. Who knows if it'll be adjourned last minute, but I'll write that down, 8/11. Because I'm very interested in Coburger. And I don't know a lot about it other than what I've read, but I think it'll be a very interesting trial. 58, population 58, Oklahoma. Because I remember when I was covering the missing moms case, the Kansas missing moms that were tragically murdered in Oklahoma. There was a town that we were looking at that had a population of something like 58. Rachel, if she gets not guilty, can we all have a ham or tofu day from Karen Reed Day? Bama supports free Karen Reed. We can do whatever you guys want. Thanks, Rachel. I'm here for you. You Will Never Walk Alone by Jerry and the Pacemakers. That's great, Siobhan. Thank you. Melissa America Rocks. Thanks for your super chat. My super sticker. Look at Captain Rhett Snuggler getting in here. Gifting 10 memberships. Thank you. Thank you, Captain. I appreciate your generosity. As do the 10 new members. Kelly, love Bethany. And to borrow a quote, I think you are Davoon, Melanie. Thanks for being here every day. Oh, thank you. Wise gal, love from YSL back in court. Ms. Love from YSL is back in court for rapper Cash Out. Going on now or going on at some point in the future, Wise gal? Thank you. Marianne, Matt McCabe's sister, is a witness against Aiden. Have pictures, and Jess Machado talks about it on Young Jerks. Janet Taylor, in my opinion, the rock that showed up could be a clue that the Alberts know what happened. Maybe the new owners found it in the yard and put it out there. Arden, thanks for your 20. Lola the good dog, if she does get convicted of an OUI, can she appeal? Hello, Larry Foreman. Is he here? I imagine she could appeal any conviction. And you know what? Maybe that's why they want it. Because if the jury wants to find her guilty of something, let them find her guilty of that. And that would be maybe an easy appeal. I don't know. I'm not an appellate attorney, but that's a good point. Lola the good dog that I have not yet considered because this is all new to me that they're now asking for a lesser included of standalone OUI. Weekend at Bevy's. Dr. Wolf rolling in his F-150. Probably has it armored like a tank, bulletproof glass, dimple reflective mirrors. Randy riding shotgun. Thank you, Weekend at Bevy's, for making this fun. You're vacationing in Greer, Arizona. Population 58, huh? Thanks, Arden, for another super sticker. Thank you, Mama Shay. See email. Haha. I will check it out later. Thank you. Oh, so you're in a town with a population of 58, Greer, Arizona. Doesn't mean you live there. You're just vacationing. Got it. Got it. And check out Better Hell by Bill Murray for the playlist. Bill Murray, like Bilmuri. Is it pronounced like Bill Murray, the SNL star? Thank you, Camille. Thank you, Camille. Flag Day is the 14th, also my birthday. Also one of my best friend's birthdays, too. It would bring tears to my eyes if Karen is free under the flag of the USA. I will never look at tofu the same way. Will any of us ever look at tofu the same way? After Dr. Basada said, ew, gross. Rebecca says they cannot use these DOA results 100%. Gigi says my BS button is arriving today. It's a deal at $10 versus therapy. That's hilarious. All right. Thanks you guys for hanging out with me today. You're amazing. You're very, very amazing. We're coming back tomorrow. Hopefully the day will be the day that Karen Reed is freed. Thank you, Arden, for another last minute super sticker. I think the sun's coming out today, and I may need to get outside. I haven't seen the sunlight in a very long time. Who knows where I'll land tonight? I'll put a community post up, so make sure you hit the subscribe button. Make sure you hit the notification button so it's set to all notifications. Thank you to the mods for keeping it classy today. 3 hours and 45 minutes and 15 seconds, which is far less than we normally are here for 7 hours, 8 hours at a time. And we've been doing it for 31, 32 days. And days in between. The days between as well have not been lost on us. Early start tomorrow. Let's come here. Let's come here and rally around 8:30. Court is supposed to start exactly at 9. And tomorrow we're going to hear closings. You want to watch Brennan's opening? It's kind of long. Do you want to watch it? You know what also is like the sound on it is so bad. Lori Daybill verdict has been reached. You know, maybe we can do it later on today. The problem is the sound on Brennan's opening is so bad. If somebody can find a feed of Brennan's opening that has good sound, I'll use it. The problem is he was not near a microphone. Maybe we can just pull up the transcript and maybe I can get Will LeGlaire to do a dramatic reading of it and we can stop every sentence and then talk about whether he proved it or not. Maybe that's an idea of something to do tonight. All right. So make sure you have your bell set. Make sure you have your notifications set because we could do that later. Because actually the video of Brennan's opening sucks and the audio sucks because he was not near a mic. All right. Wouldn't that be great? I'll see if Will's up for it. What time tomorrow? Come back at 8:30, but we may do something tonight that I just thought of. So I think that would be great. Good idea? Okay, cool. Thank you, moderators. Love you all. Everyone do all the things that YouTube likes. You know what to do. Hit the button, hit the bell, hit the like button, subscribe, do all the good things that YouTube likes. Stay cool, stay kind, stay classy until later tonight if I can get Will on board with me. Go over to Young Jerks or whoever is streaming the Aiden Carney trial and prayers up for Aiden Carney. He's opted for a bench trial on this case that is against him for, I think, Lindsay Gattani is the victim here. Not announced yet that the Lori Daybell verdict is in. All right, you guys, go do the things, go do the stuff. But wherever you go, tell them I sent you. Stay cool, stay kind, stay classy. I love you guys. I'll see you later tonight and tomorrow morning at 8:30 for the day that hopefully Karen Reed is freed. Everyone get a good night's sleep. We will be eating cupcakes all weekend, says Lil the good dog. I love you with all of my heart. If I don't see you soon, I'm going to die, which is why I'm going to see you soon. Okay? Peace, everyone.